Welcome from Olomouc. I can see that we are facing some technical issues at the very beginning. At the same time, if I have a correct information, we are awaiting connection of Professor Pavel Šturma. So please give us just a few minutes. We are definitely start within few minutes.
Right. Good morning, ladies and gentlemen. Also from me, it's my great pleasure to welcome you to the conference on the ICC's contribution to the development and enforcement of international humanitarian law, which takes place today and tomorrow as an event which is supported by the European Society of International Law and by the Czech branch of the International Law Association. We were very much looking forward to welcome you in person in Olomouc. So we attempted, and we were hoping that we will be able to welcome you here. That's why we also postponed the conference. Unfortunately, the situation is still not good enough to meet in person. That's why we have chosen the online format. My name is Martin Feix. I'm the head of the Center for International Humanitarian and Operational Law, which is organizing this conference. Also with me here is Professor Andrej Svaček, who is the co-organizer of the conference and a member of the center as well. Now we have two welcome words, one from our dean, Professor Václav Stehlík, And the second one, hopefully with from Professor Pavel Šturma, will hopefully join us soon. He's working on the connection, which is something which we of course expect that there might be some technical difficulties, but we hope that he will be able to sort them soon, sort them out soon, and join us for the conference. So now I would like to give the floor to our Dean, Professor Stehlik.
So thank you very much. I hope that everybody can hear me and the connection works.
We can't hear you.
Let's check. You can't hear me? No, the connection doesn't work as it should actually. So I'm trying to check where the problem is.
Now
I can hear. I can hear very well.
Oh, super, super. So somewhere the connection goes and somewhere maybe not, but I hope that all these technical issues will be settled during the or before the session starts. So thank you very much once again for giving me the floor. Dear ladies, gentlemen, dear colleagues, friends and guests, I would like to very much welcome you here at the Faculty of Law in Olomouc and this conference, this session. Unfortunately, as Martin said, this session will be held virtually. We have no other option. But I feel that the problems you are going to discuss are real and even maybe more pressing in these times when the world is occupied with the pandemics. So I hope that the physical and intellectual connection will be good and the online form will not be a barrier to substantive debates. On contrary, as I could see, the online form enabled that we have a very broad participant list, and this online session enabled together really prominent speakers, scholars, researchers from nearly all over the world. So it's very pleasing and it's very fine that this could happen. So it's my great pleasure to welcome you here to this session, and I wish that all of you will enjoy it. It will be useful for your work, for your research. It will be an inspiration as well. And as Martin said, I hope that the next session could be held here in Olomouc and we could meet personally at the premises of the Faculty of Law. At this moment, please allow me to thank very much my colleagues, Associate Professor Andrej Svaček and Dr. Martin Feix, for organizing this traditional event on behalf of the Faculty of Law, Department of International Law, and Center for International Operation Law. So thank you very much for this, and I'm sure that the organization will be very good and excellent. So dear colleagues, very shortly, you are much welcome at this session. I'm not sure whether Professor Šturma is here, and I can see he is here. So I would like to also very much welcome our dear colleague, Professor Pavel Šturma from Charles University in Prague, who is also the chair of International Law Commission and who will kindly chair the main panel in the morning. So dear Professor, dear Pavel, please, I give you the floor to your welcome words, and you are much welcome. So thank you very much for your attention, and I wish you that you enjoy the session. Thank you very much.
Hello, good morning. Dear Dean, dear Václav, thank you for your kind words at the very beginning. Dear colleagues, it's also my honor and pleasure to say a few words at the beginning of this conference. I think that now it is not to enter into substantive debate, but I would like to congratulate my colleague from the Department of International Law, Andrej Svaček, Martin Feix, who became organizers of this conference. As it was already said by our dean, I think that we would all prefer to meet in person, to have a traditional classical conference is the exchange of views in person. Unfortunately, it is not possible. It is another conference organized either in Prague or Olomouc, by technical means online. But I think that it is good that we didn't stop doing not only our teaching, which we also have to conduct online, but also our research activities and conferences. And I think that the topic of this conference is extremely interesting, and I will show them. Of course, it concerns the interaction between two of three quite important and developing areas of public international law today. I have in mind human rights law, international maritime law, and international criminal law. So today it is about two out of three areas of international law, namely international humanitarian law and the influence, the impact of the international criminal law, the activities of the ICC, International Criminal Court. I think that it is not unusual today that not only academics but also practitioners have to think about mutual relations and effects, supporting effects of different areas of international law. Sometimes they are subject of research concerning criminalization of human rights law. I think that one of the examples could be also the recently adopted draft articles on prevention and punishment of crimes against humanity, adopted by the International Law Commission in 2019. However, today it is more about what was traditionally called the law of war, today international humanitarian law, and the influence of the ICC. It is well known that in the past, the activities of the international ad hoc criminal tribunals, ICTY, ICTR, greatly contributed to interpretation and development of customary rules of international humanitarian law. But the period of those ad hoc tribunals is over now, and I think there is plenty of literature dealing with that, supporting but also criticizing sometimes very activist approach of those tribunals. Now we have the Permanent International Criminal Court, and I think that this court works in a partly different legal circumstances, different from those when two ad hoc tribunals work. But I think that it is also very important to look closer at the activities of the ICC and how the ICC contributed to interpretation and possibly development of IHL. And I think that there are some examples, for example, Mahdi case concerning the protection of culture property and the destruction of the property, cultural property as a war crime, etc. So I think that there are also many other interesting areas concerning both substantive and procedural aspects of the activity of the ICC. And I think that why this conference may come with some very interesting contributions, and that's why I would like to wish the full success to all participants and organizers of this conference. So thank you for the attention.
Thank you, Professor Sturma, for being here with us and also for these welcome words. We were supposed, according to the original program, to have also a welcome word from Professor Farah, a member of the ESIL board. But since there is a time difference and he will join us from the United States, he will give his welcome word at the beginning of the afternoon session today. Now I would like to take the floor together with my colleague Ondřej Svaček, and first to briefly introduce the center which is organizing this conference, then I will hand over to my colleague to for framing, let's say, the topic of the conference and how it came actually into being. And finally, I will just have some, let's say, practical advice or some technical issues concerning how we should proceed also in the discussions and so on. So at the as the first step, I would like to briefly introduce the Center for International Humanitarian and Operational Law, which was established here at the Faculty of Law in Olomouc, and it's a joint center established together with the Czech Army. So the core members of this center are scholars from the Faculty of Law and military lawyers from the Army of the Czech Republic from different units. It's a result of a long-standing cooperation which we have with the Czech Army, and basically we are a research and teaching hub for the areas of international humanitarian law, international operational law, use of force and security issues in general. We have a pool of external experts, doctoral students, guest researchers who research and teach on a variety of topics and do come from different countries. In general, the principle of diversity is very important to us, and we are committed to bring together people from not only in terms of geographical diversity from different countries and different continents, but also professionals from different jurisdictions and with different background in terms of practitioners and scholars, but also we try we are committed to diversity in terms of, let's say, seniority in international law. And this conference is a proof of this, because we have chosen speakers who are holding senior positions in international law. And we have also colleagues who are at the beginning of their careers. One of the main activities which we are particularly, let's say, proud of from the center, or organized by the center, is Camp ERA, which is a life simulation training. If you allow me, I will just share a couple of slides. All right, so I hope that you can see this. All right. Camp ERA is a life simulation training which we developed together with the Army. It's taking place in a real environment of a military training area close to Brno, the second biggest city of the Czech Republic, and it applies an interdisciplinary approach. That means that it combines different areas of international law, also with relevant aspects of domestic law, but also of extra-legal aspects, such as providing healthcare in situations of armed violence. It applies specifically the method, a specific method of teaching, which is educational live action role play, which proved to be quite an interesting way how to bring the practice of IHL closer to the students, so get out of the classroom and bring the IHL to the students a bit closer. We are connecting, or this exercise is connecting relevant actors from the field, so not only scholars and experts from the academia, but also, as I said, military lawyers, but also also people from the ICRC, Czech Red Cross, the UNHCR, and relevant national authorities. So the main focus and the main aim is to connect the theory and practice, and to give the students the opportunity to experience IHL, especially IHL, in a different way. So this is just a brief introduction to the center and its, let's say, activities. Now I would like to hand over to my colleague, Professor Svaček, for just sort of framing the conference, and then I will give you some practical instructions, let's say. Thank you.
All right. Thank you very much, Martin. Can you hear me? I hope so. All right, so it's also my pleasure to welcome you at our conference. To be frank, I have survived my own clinical death in previous minutes because internet connection is very unstable here because of heavy snow load probably. So right now I'm connected through my data, so hopefully it will be stable. It goes without saying that I would definitely prefer personal meeting in Olomouc. So we would love to show you hospitality of our beautiful university city. But at the same time, I'm very much grateful even for this cyber form of meeting. I must mention what you already know very well, that organization of whole event was really grossly influenced by a recent pandemic. We were forced to reschedule it. I must even admit that at a certain point of time, one of the possible scenario was even the cancellation of whole event, since simply no new feasible term was in sight. We were at the same time not sure that the new term, if selected, would suit well to invited guests and speakers. So, by the way, Czech Republic right now is in a more or less total lockdown. Borders are closed for aliens. So it seems to me that the conference was born to difficult times, but fortunately, we have overcome some childish illness. In that respect, I can say that the rescheduling simply couldn't fit all. To give one example, our excellent speakers in the opening panel should have been originally accompanied by Judge Fremer with his contribution on evidentiary challenges in Taganda case. So for me personally, given all COVID-induced difficulties we faced during organization, it is almost a miracle that the conference grew up. So I must give you a credit. Thank you very much for your support. Thank you very much for your participation. Let me now briefly introduce the content of the conference. I have already referred to the Taganda case, which was a starting point of our considerations. These were mainly 2017 decisions on jurisdiction of the International Criminal Court in relation to intra-party sexual war crimes against child soldiers, which gave very title to the opening panel. So as you will see, this topic is even some kind of imaginary thin red line in the background of some other contributions. So these decisions gave title to the opening panel and also turned our attention to development of international humanitarian law by the International Criminal Court. Enough is to say here that these decisions made a snowball effect in the doctrine. We just produced a large amount of writings exploring whether the criminalization of intra-party offenses as war crimes is in line in contemporary IHL. Some authors speak about the Tadic moments, some are very critical and speak about unwarranted judicial activism. This is exactly what we would like to discover, what we would like to address here at our conference. When assessing the ICC's contribution to the development of IHL, we found necessary, firstly, to address the issue of mutual relation between these two branches of international law, be it the law of ICC or ICL and IHL. And at the same time, given the existence and the relevance of Article 21, Para 3, even of the Rome Statute, even we must take into account even the international human rights law. So these aspects will be covered in the second panel, which will, among else, also raise a provocative question whether IHL truly needs further development by international criminal courts. In the third panel, we follow a very straightforward line. This panel concerns issues of substantive law. So the line is context, crime, forms of responsibility, and grounds excluding criminal responsibility, or at least mitigating circumstances. We reserved, as you can see, two contributions to the contextual element, which is at the very heart of Article 8 of the Rome Statute. Concerning selection of crimes and circumstances excluding criminal responsibility, we chose those which are very typical for child soldiering. Concerning form of responsibility, we focus on superior responsibility as it is very closely connected to IHL. Enough is to refer here to Article 87 of Additional Protocol 1. In the third panel, we will address procedural issues. By the way, procedure is understood here in the widest possible sense. This panel actually opens the enforcement part of the conference. We believe that enforcement and development are communicating vessels, to mean that without enforcement, any development is simply impossible. If you look into the program, we will address institutional synergies. We will touch upon unique feature of the ICC proceedings, which is the reparation for victims. We will then explore some particular aspects of cooperation, which is, as it's widely known, absolutely crucial for effective functioning and operation of any international criminal tribunal. Finally, we will focus on tribes of jurisdiction, immunities, and last but not least, cumulative charging. Well, this is probably the shortest possible flight over the reservation of our conference in Olomouc, which should provide participants with, at least in certain aspect, complex overview of the prosecution of war crimes before the International Criminal Court. So please remain seated, fasten your belts. I guess that we might begin and enjoy the ride.
Thank you, Andre. Before I hand over the floor to Professor Šturma, just a few words of, let's say, in practical terms. I would like to draw your attention to the fact that in the email which we sent you with the Zoom link, you will find also a link to a folder with outlines and presentations from the speakers. So you are most welcome to look in them and to get the information. And I would like to kindly ask our speakers to stick to the allocated time, which is 20 minutes for each of the presentations. As for the discussions which should follow each of the panel, there is basically two ways how you can raise your question. First is to write to the chair of the panel in the chat. So use the chat here in the Zoom and to write your question, which should be directed to the chair of the panel. Or you can simply raise hand or use the raise hand option, which you will find at the bottom of the Zoom panel. There is a button called reactions, and there you have the raise hand. So I will just raise the hand just to show you how it works for those who don't know this. So the chair of the panel will then have the chance to collect questions from the chat as well as from the audience after raising the hand. As I announced, or as we announced, the conference is being recorded and it will be available also via YouTube channel of the law faculty. The link to the YouTube channel was provided to everybody also in this email with all the links, including the link to this Zoom. For tomorrow, please use also the same link as today. And if you should experience any difficulties or should you have questions, we will try to sort them out. We have our IT guru with us, Mr. Voigt. So I hope that we will be able to help you with everything. So this is in practical terms, and now I would like to give the floor again to my colleague and eminent Czech international lawyer, Professor Šturma, to chair and to start the first panel. We can't hear you, Professor Šturma. You are still muted.
Yeah, thank you. Yes, thank you. Yeah, this is the microphone. So once more, Martin, thank you for your introduction. As far as I understood, we should not have a break now. We should open immediately the first panel concerning the problems of child soldiers and related issues. So I think that if I am not mistaken, there is a slight amendment in the sequence of speakers, and I think that the first speaker should be Judge Renate Winter, right? I think that let me so introduce Judge Winter. I think that she served as an appeal judge of a special court for Sierra Leone from 2002 to 2013. She held position of interim president, vice president, and for 2 years also position of the president of this court. She previously served as international judge of the Supreme Court of Kosovo as a part of the United Nations interim civil administration in Kosovo. And she's an expert on family law as well on juvenile justice systems, etc. Since 1981, she has been judge at the Vienna Youth Court, where she has undertaken projects to help rehabilitate youth with problems of drug addiction and mental disability. Dr. Renate Winter has also worked on projects relating to youth and child soldiers for the United Nations, including in numerous African countries. And she also has dealt with issues of organized crime and restorative justice. She has served as the president of the International Association of Youth and Family Court Judges, and since 2013, she has been member of the United Nations Committee on the Rights of the Child. And since February 2015, she was position of vice president of the committee. And last but not least, she has been also appointed judge of the Residual Special Court for Sierra Leone in 2013. And she served as president of that Residual Special Court from December 2016 to December 2018. So she's extremely competent in the area concerning the situation of child soldiers. And now I would like to introduce a contribution on the topic Children in War Situations, the Special Court of Sierra Leone, and the Committee of the Right of Child. So Judge Winter, you have the floor.
We can't hear you, unfortunately. Judge Winter, would you, thank you.
I try another time. Is it possible now? Okay, fine. My greetings to all of colleagues and participants, first of all, from the very beautiful town of Tbilisi in Georgia, where we have spring already and no snow at all. I am very honored to be invited to have the first speech here. And I'm very sorry to tell you that I have to leave very, very soon afterwards, because I have to chair the last session of the last day of the session of the Committee of the Rights of the Child. I am sorry, it was a very bad coincidence. I have seen the very sophisticated program with all the distinguished university professors and the heavy load of fascinating legal problems. And I decided, being a judge bound to solve problems, and coming from the CRC, bound to deal with children, to do just that. Not discussing heavy legal issues, because you are going to do that for 2 days anyway, but to speak about children in very different war situations and trying to find out how to solve their problems if ever possible. I came first in contact with the problem of child soldiers during a visit to Iran after the war, Iraq-Iran war. I visited a place without knowing where I was and was attacked by an Iranian who asked me what the hell I am going to do there and what the hell I am thinking about not honoring people laying there. It was a cemetery. It was the cemetery of the children of the Iraq War, Iraq-Iran War. 30,000 children, child soldiers, killed during the Iraq-Iran War. That was my first encounter. My second was in Colombia, where I had to deal with child soldiers and trying to get them out from the different warring factions. I met 12 girls aged 9 to 14, having been child soldiers their whole life, starting with 8, and having been raped, had abortions between 9 and 12, wanted to become a nurse and could not become nurses after demobilization because they had no school. Finally, I came to deal with the child soldiers in Sierra Leone that were approximately 10,000. And they were used by all warring factions without any difference. What are the problems that we have? And you can imagine that as a judge dealing with children and dealing with this kind of children, you are asking yourself, but what am I going to do with them? What can anyone do with them? What has justice to do with them at all? Because all of them, all those children we have met and we have had to deal with, we are all, in the sense of penal justice, criminals. Children in conflict with the law, as we say in the Committee of the Rights of the Child, because they have committed crimes you cannot imagine, and I'm not going to tell you because then you cannot sleep as I cannot. Crimes that are so horrendous that not one single adult soldier has ever committed them. But they all were in situations where they had no choice. I'm coming to that a little later. The problems that we have are that we have approximately 500,000 children in armed conflicts, approximately, more or less, according to the reports of the different reports of the Secretary Generals. And we have roughly 350 million children affected by war. Children as soldiers in armed conflicts, whatever kind of armed conflicts. Girls, especially, abducted to become bushwives, to provide arms, to steal to provide arms, to deal with arms, and once again to commit atrocious crimes. First of all, because for the very first time they are equal to boys, being a soldier. We have internally displaced children in the thousands who have, yes or no, forced to commit, to work as child soldiers. And we have all the abducted children. My youngest abducted child as a child soldier was 4 years old. And he was smaller than the Kalashnikov he had to carry. He did not know where he came from. And after demobilization, and this is also our problem, he did not even know where home was, where their parents were. So how we are going to get them home, these children? We have a lot of international documents. The CRC, first of all, Article 38, who is very, very categorical concerning all children under the age of 15. We have the ILO Convention 182, which, that condemns the worst forms of labor, where war and warlike situations are mentioned. We have the optional protocol to the CRC on the involvement of children in armed conflict, where we have elevated the age where children can become soldiers to 18, with some exceptions concerning 16 to be at a military school. We have the African Charter of Child Rights. We have the Rome Statute. We have the decision of the Special Court of Sierra Leone on soldiers, the very first one, by the way, because we were the very first court who decided that using children as soldiers is a war crime and a crime against humanity. Once again, in my last 10 minutes, I hope I can come to that. There are a huge amount of problems that we had to deal with from the very beginning. But I forgot just to say that we had already also some information about human rights and humanitarian law, the Geneva Conventions, and also the Islamic law, who is very categorically also concerning child soldiers if we go to the classical Islamic law, not to ISIS and terrorist group and so on. They, as you know, they are quite different. Now, I would like to speak a little bit about our problems that we have, the legal problems that we have. These were the practical ones that I mentioned. The legal problems in the beginning, as I said, we were the first court to deal with child soldiers. And we had a big problem because our mandate, as decided by the General Assembly of the United Nations, were to deal with only those who bear the greatest responsibility, On the other hand, we are the only one international and hybrid court that has the mandate to deal with children, especially children that are over the age of criminal responsibility, which is in Sierra Leone 14 years. So we decided, fine, we have that mandate. We have to deal with persons bearing the greatest responsibility. I have never in my life as a judge and in my private life, ever seen that a child bears the greatest responsibility for war situations. Never. And therefore we decided we are not going to deal with children as accused persons in our whole procedures. We have them as victims and witnesses, but never as perpetrators of crime. If we would deal with children, maybe children over the age of 14 to 18, not even those we could deal with, because we do not have any age. If you ask a child, how old are you? The child will tell you, I do not know. You try to find the parents tell you, yeah, the child was born, if I remember correctly, during the high rainy season, in the year where we had before the drought. Do you know now when the child was born? And if the rainy season goes from one year to another year, which year is this child born? And we have to have a correct date because otherwise we cannot decide if this child is, yes or no, criminally responsible. And concerning all the children from the very first age of 4 until the age of 18 that were soldiers in the country, they were constantly put under drugs, constantly, from all varying fractions. How can we, the judges, decide that this is now a situation where something happened, where this given child was not drugged or was not under the influence of drugs? How are you going to decide that? And that was the reason that we said, no way, we are not going to deal with children as soldiers. We have had, I would like to give you a little bit of the legal issues that we had to fight with. The answers most probably will be given by the professors and by the researchers later on, because we had to deal with the problems of the differences between jus ad bellum and jus in bello. We had the difference between state actors and non-state actors and their responsibilities, because whatever we did, there was a professor or a lawyer coming and say, it does not work because of, you do not have the jurisdiction because of, and so on. I will give you a very few examples. The special court has no jurisdiction to try the accused for crimes prohibiting the recruitment of children into the armed force or groups or using them to participate actively in hostilities, since the crime of child recruitment was not part of customary international law at the time. Consequently, the special court statute violates the principle of nullum crimen sine lege and nullum crimen sine poena. While Protocol 2, additional to the Geneva Convention 77 and the Convention of the Rights of the Child, may have created an obligation on the part of states to refrain from recruiting child soldiers, these instruments did not criminalize such activity. Nullum crimen sine poena, on top of it. The Rome Statute of International Criminal Court criminalized child recruitment, but does not codify international law. The answers we found were listed in our judgments. I give a short overview. I have 7 more minutes if I am correct. Please, Chair, stop me if my time is over. The crime of child recruitment was part of customary international law at the relevant time. I checked personally 128 different jurisdictions to find out of civil law, common law, Muslim law, to find out if yes or no their child recruitment or other forms of bringing children in such situations were customary law at that time. The number of states that made the practice of child recruitment illegal under domestic law and the subsequent international conventions addressing child recruitment demonstrate the existence of this customary international law. The principle of nullum crimen sine lege could not be rigidly applied to an act universally regarded as abhorrent. Because I had one of the accused who said to me, "Madam, it's maybe not really ethical to use child soldiers, but it's not a crime, so let me free." And he was laughing. We had to deal with the prohibition on the recruitment of child soldiers that has acquired a status of crime under international law. Because the defense argued that a prohibition under international law does not necessarily entail criminal responsibility, and so on and so on. If we said one thing, people came to say, no, it's not possible because anything else. We found that individual criminal responsibility for child recruitment had become established already by April 1997, when the Cape Town principles were adopted at the Symposium of the Prevention of Children into Armed Forces and Demobilization and Social Reintegration of Child Soldiers in Africa. That already was a part, but it provides that those responsible for illegally recruiting children was established. So the defense immediately said, what do you mean by illegally? The state party legally recruited children. And what about recruiting children? There are other forms than recruiting also. What about those forms? So we had to go into a real lot of details to come to the conclusion that child, I have no time to explain all the issues. You can, as I said, you can find it in our decisions if you're interested in to recruit children under the age of 15, which was later on then, because of the first additional protocol, the age of 18, is a war crime and is a crime against humanity. My time is over, as I can see, but I would like to give you at the end a very, very small story. about a child soldier in another African country. I visited a prison in another African country after a huge civil war. And in this civil war, again, everyone has used child soldiers, and quite a lot of child soldiers were in a prison. In this prison, that was a room 30 to 20 square meters square, and maybe 5 meters high, I had 180 boys. 180 boys for 3 years without ever leaving that room. I came across a little child, a very small child, and according to the law of this country, children are criminally responsible after 14 years of age. I came to that very little boy and I asked him, "How old are you?" And he said, "I am 8 years old. I am here since 3 years." He was 5 when he was sent to prison, and I asked him, what have you committed? What have you done? And he said, "Madam, I am genocidaire. I committed genocide." I said, "What is genocide?" And he said, "Madam, I don't know." This is what I would like to bring to your attention when you speak about the huge and very certainly interesting and very certainly fascinating legal problems. When I left the prison, the little one came to me once again and said, Madam, do you think that I will see the sun once again?" He did not. I thank you very much for your attention.
Thank you very much, Judge Winter, for your excellent contribution. And I think that as far as I understood that you would have to leave us earlier. So that's why I can allow now, in case of some questions, to give chance to participants to ask questions directly to you, and this will give a chance to you to answer before introducing next speaker. So in case there are no questions now, I don't see any. So thank you once more for your intervention. And according to our program, I would like to introduce the next speaker, Dr. Petr Válek. Petr Válek has been the director of the International Law Department of the Ministry of Foreign Affairs of the Czech Republic since October 2012. Prior to his current position, he was posted as legal advisor at the Czech Permanent Mission to the United Nations in New York. He worked as a legal officer at the International Department of Ministry of Foreign Affairs and also in the United Nations mission in Kosovo in 2007 and in the Coalition Provisional Authority in Baghdad in 2004. He also did his military service in the Czech army. Mr. Válek studied at the Charles University Law School in Prague, where he received both his master's degree and PhD. I must say that he was my student. And he also studied at the Goethe University Law School in Frankfurt am Main and at the University of Michigan Law School in Ann Arbor, where he gained an LLM degree. From 2017 to 2018, he served as a vice chair, and from 2019 to 2020 as the chair of the CAHDI, the Committee of Legal Advisors for Public International Law, Council of Europe. So he will present his contribution on the topic, the criminalization of recruitment and use of child soldiers as a case study in development of international law. So, Petr, the floor is yours.
Thank you, Pavel, for this kind introduction. I would like to also thank Martin and Andrzej for organizing this wonderful event. I think it shows that even in this COVID-19 times, we don't have to give up, having conferences on public international law issues. So thank you for this. The title of my topic is, as Pavel said, the criminalization of recruitment and use of child soldiers as a case study in development of international law. And I would like to start by saying that the topic of child soldiering is relevant today. It can be demonstrated by the agenda of the UN Security Council that has a special item, Children and Armed Conflict, based on the resolution 1612 from 2005. And the Security Council even established a working group on this issue. I would like to also recall that one of the 3 finalists for the Václav Havel Human Rights Prize of the Council of Europe this year is Mrs. Julienne Lusenge, a human rights activist from the Democratic Republic of Congo, who played an important role in documentation of recruitment of child soldiers and provided evidence to the ICC in the Lubanga and Katanga cases. So I will focus not only on the issue of child soldiering under the IHL, but approach this question in a wider context from the point of development of international law. Let me say at the beginning that the issue of child soldiers has been always present in armed conflicts. In the recent years, it was even registered or seen by the Hollywood production, where most of you perhaps know the 2006 movie called Blood Diamond, starring Leonardo DiCaprio, and the movie is set into the Sierra Leone civil war. This movie clearly shows why the children are used in armed conflict. First, children can be easily manipulated and brainwashed. And second, those of you who have children and know how they quickly learn to operate new things like tablets or iPhones, the children, they can also learn quickly how to operate weapons. So that's also another element. Finally, in the situation of armed conflict, the option of joining an armed group might be the only way how to survive. The phenomenon of child soldiers has been covered by the international humanitarian law. I would like to start by the 4th Geneva Convention and Article 24 that covers general protection for children, and Article 51 of the 4th Geneva Convention that prohibits the occupying power to compel protected persons to work unless they are 18 years of age. So, if you look at the 4th Geneva Convention applicable in international armed conflict, you will see that there is very, very little when it comes to the recruiting and use of child soldiers. This is relatively surprising because, the 4th Geneva Convention was adopted right after World War II, when the use of children was quite frequent, particularly on the Eastern Front. And at the end of the war, perhaps some of you recall the use of children in Volkssturm and Hitlerjugend. So as you could see, there was a certain legal gap in IHL when it comes to the recruiting and use of children. This legal gap was closed by Additional Protocol 1 to the Geneva Conventions from 1977 that provided clearly in Article 77 that the parties to the conflict should not conscript children under the age of 15 and use them to take a direct part in hostilities. A similar provision is also in Additional Protocol 2, applicable in a non-international armed conflict, and you can find it in Article 4, Paragraph 3. And then there is also a massive body of international human rights law that was already mentioned by Judge Renate Winter, and that is the Convention on the Rights of the Child, Article 31, prohibiting the recruitment of children under the age of 18. And then the 2000 optional protocol to the Convention on the Rights of the Child on the involvement of children in armed conflict that prohibits, the involuntary recruitment of persons under the age of 18. So as you could see in international law through the development in the second half of the 20th century, what we've got was a clear treaty law-based, almost universal prohibition for the parties to the armed conflict to recruit children in the armed forces or groups and to use them for participation in hostilities. Now, in particularly in the Czechoslovak science of international law, we are very strict in distinguishing the primary rules and secondary rules of international law, as Professor Sturma might confirm. And so what I have described now were just the primary rules, containing a clear prohibition to recruit and use the child soldiers. When it comes to the secondary rules, the rules that establish what happens if the primary rules is broken, the first treaty coming into this was the 1998 Rome Statute that was also mentioned before, and it's Article 8 defining the conscripting or enlisting children under the age of 15 years as a war crime, both for international armed conflict and non-international armed conflict. At the point of the drafting of the Rome Statute, there has been the question whether these secondary norms, these criminalization norms in Article 8, were actually codification or progressive development of international law. And although this debate might seem academic today, as was pointed out by Judge Winter before, for the Special Court for Sierra Leone, this question became quite practical. As was mentioned before, the statute of the Special Court contained a similar definition of this war crime, conscripting or enlisting children under the age of 15. And as it was said also, it was used in the Samuel Hinga Norman case, which was the government guy. He was the deputy minister at the Ministry of Defense of Sierra Leone. And in this capacity, he recruited hunters from the tribes in the south and east of Sierra Leone, including children. The defense lawyers of Mr. Norman claimed actually that the Special Court for Sierra Leone lacks jurisdiction for this particular crime because at the time of commission, this particular crime was not a part of customary international law. And here I should also underline that the jurisdiction of the Special Court for Sierra Leone, ratione temporis, started since November 30th, 1996, so even 2 years before the adoption of the Rome Statute. The appeals chamber of the Special Court expressed some doubts, nevertheless rejected this motion for the lack of jurisdiction. It also used the so-called Tadic case test. I mean, this is a famous Tadic case before the ICTY. And in the Tadic case, the ICTY dealt with the secondary rules, with the criminalization of war crimes committed in a non-international armed conflict. And here the appeals chamber of the ICTY in the Tadic case set 4 basic conditions for the individual criminal responsibility to arise. The first one was that the violation must constitute an infringement of a rule of international humanitarian law. So this was clear in this case. The second one was that the rule must be customary in nature, I mean the primary rule. The third condition was that the violation must be serious, which was also met in this case. And the fourth condition was that the violation of the rule must entail under customary or conventional law, the individual criminal responsibility of the person breaching the rule. So the fourth condition, that there is actually the secondary rule, was a key, and it was the harder one to prove. As Judge Renate Winter said before, the appeals chamber went through the state practice, criminalizing this behavior, and the motion was denied. But I would like to also mention the dissenting opinion of the British Australian judge Geoffrey Robertson. I mean, it's a very well known in the area of public international law. He has been also a defense lawyer of Julian Assange. And Judge Geoffrey Robertson questioned that the fourth condition, the criminalization under international customary law, was actually met. He admitted that it was meant for the forcible recruitment, but it was not meant for the voluntary enlistment. He based his argumentation on the travaux préparatoires of the statute, where the UN lawyers, the lawyers of the UN Secretariat, raised some questions regarding the customary law status of this crime. I would like to quote his one sentence of Judge Robertson. If it was not clear to the Secretary General and his legal advisors that international law had by 1996 criminalized the enlistment of child soldiers, could it really have been any clearer to Chief Hinga Norman or any other defendant at that time embattled in Sierra Leone? So this is a very interesting point. Now I would like to add my personal evaluation of the judgment, and seeing Judge Winter, I know I have to be very diplomatic now at this point. First of all, I would like to say that when I read the judgment for the first time years ago, I was convinced pretty much by Judge Robertson. But now, after more than a decade of practice in international law, I have to say that I'm a bit less critical now, because I myself, in the job of legal advisor of a government, witnessed how difficult it is actually very often to prove customary international law in different areas. To add some criticism, it might be said that the ICTY appeals chamber in the Tagi judgment perhaps assembled a little bit more amount of state practice than the special court appeals chamber in the Norman judgment. But overall, I found the judgment convincing. At the end, I would like to also ask a philosophical question. To what extent, and this is something that is very hard to explain to a non-lawyer, why this distinction between primary and secondary rules of international law, why does it really matter so much? If certain behavior is clearly prohibited, to participants in the armed conflict, why should it be, written somewhere else that it's also a crime? I mean, if something is prohibited, that particular person should not conduct such behavior. It's also true that the judgment of the appeals chamber fit into the general trend of broadening the individual criminal responsibility, and also to the general trend of towards the end of impunity. It could be demonstrated by the ICRC study from 2005 called Customary International Humanitarian Law, where we have Rule 156, which is about conscripting or enlisting of children under the age of 15 years into armed forces and using them to participate actively in hostilities. And here the ICRC in 2005 came easily to the conclusion that this is customary international law. As an epilogue, the child soldiering has been quite often before the ICC, starting with the first Lubanga case, then with Kony and Koti cases in Uganda, and most recently on February 4th this year, we had the Ongwen judgment where he was also found guilty for conscripting of children under the age of 15 into the Signa Brigade. I would like to finish my statement by conclusion that it is probably not very realistic that the problem of child soldiering will disappear. Unfortunately, it will be present in the future armed conflicts again. What is important is that the perpetrators of recruitment and using children are prosecuted, and you know, the case study that I just mentioned in the development of international law is for me, you know, one of the arguments for the standing treaty-based international criminal court, you know, working pro futuro, where, you know, the motions such as the one in the Norman case, you know, simply would not have legal chance. Thank you.
Thank you. Thank you very much, Peter, for your interesting contribution. And I think that now, unless there are some urgent questions or comments, it doesn't seem. Yes, okay, I will give the floor to Judge Winter, please.
Just a very quick answer to Peter and his very valid arguments. The first thing concerning Judge Robertson was that he said, as you mentioned, how could he know Hinga Norman? How could Hinga Norman know if it was not yet criminalized? It was customary law, and this customary law was known in Africa, in almost all states of Africa at that time. But there is a possibility to say, he could not know, or he would not have known. But as the minister in power, he has to know. Either he knows, or he has to know, or he has a good reason why he could not have known. None of that has happened. And the last thing that also would be a possibility for him to say, okay, I could not follow, is that he said, I did not know, or I could not do otherwise in good faith. This is also a possibility foreseen. But good faith was not there when he said in the open, you cannot do anything against me, because I can do what I want in my country. This kind of things, I'm not citing now verbally exactly what he said, but only the content. So just to be on the safe side. Therefore, I unfortunately cannot stay for the discussion, therefore I wanted to say that. And the second part that we had to deal with, and I say it very quickly, is that we had first to prove that it is a crime at all, which we could. And then we had to prove that there has been punishments, because the defense said, yes, at the end it is a crime, but because it was just mentioned as a crime, but never a punishment was given, and never punishment was an issue, you cannot punish. But there was a punishment, and this is what we could prove when we went through, as I said, 128 different jurisdictions, that there was always a combination between a crime committed and a punishment. For instance, a crime committed by an officer, and an officer being an administrator, a member of the administration of the country, is liable also under punishment of people of the administration. So to put all those combinations together, we could show that in 128 countries, soldiering children was punished, and therefore we could come to our conclusions. Thank you very much for giving me that time. I unfortunately cannot stay quite much longer, a few 10 more minutes, and not longer. Thank you very much for giving me that time.
And in this case, I will maybe transmit a message I found in the chat from one participant who wrote, I'm wondering whether Judge Winter will stay for discussion. If not, I would really like to hear her views on the Ongwen case concerning, as we know, the responsibility of a former child soldier for war crimes and crimes against humanity. So maybe if you wish to say a few words, maybe it would be a good combination of two questions at this moment.
Thank you very much. I will try very quickly once again. I think if I understood correctly, it is the question was about the punishment of a child soldier in an elder state as we have had before the ICC. Is this correct?
Actually, it is written on the chat, and it is a reference to the Ongwen case.
Yeah.
On the responsibility of former child soldier.
Yes, yes. The point is that we had there as well, you have to distinguish when the person was a child soldier under a very early age, and then later on, when it was proved that he was over the age of criminal responsibility already, and still continuing. And in this case, the first part of his life can certainly not be taken into consideration. The second part, yes. But with the second part, we then have as well the whole situation of evaluating the influences on him when he was a child, the influences, if there were drugs at play, and so on. So it is true that this person can be punished for what he has done, but the way of punishment and what the punishment should be has to be very much taken into consideration concerning his former life and the influence. If you are a child soldier at 4 years already, and at 15, you are still child soldier. It's not easy to say at 15, 16 or 17, okay, I am abstaining from everything. No? On top of, if yes or no, you have a commander who would allow to do you that. In the Ongwen case, the man was already quite high on the hierarchy.
Okay, thank you for your comments. Maybe, I don't know whether Petr Válek would like to intervene now? No? Okay, so in this case, thank you very much. And I think that we can still continue our discussion at the end of panel, and also following two comments by Professor Klaus Kress. But now I think that I should give the floor to another speaker, to Gus Washeford, who is a senior lecturer at the School of Law, University of Essex. Prior to joining the University of Essex, he held academic appointments at the University of Pretoria as lecturer and the University of South Africa as associate professor. Between 2011 and 2013, Gus was appointed as legal advisor to the United Nations Special Rapporteur on extrajudicial, summary, or arbitrary executions. Gus has also been a visiting researcher to the International Law Center of the Swedish National Defense University, as well as the Center for Human Rights and Global Justice at New York University. Gus' primary research interests relate to contemporary challenges in the context of armed conflict in Africa, including working towards enhancing the level of participation from within Africa in the global discourse on the law of armed conflict. With a background in photojournalism, Gus has extensive experience working with active conflict zones in Africa, including the Democratic Republic of the Congo, Liberia, South Sudan, and Angola. In 2015, he published a book, International Law and Child Soldiers. So now I would like to give him the floor. His topic is reconsidering the scope of protection of IHL, the notion of own force violations committed against child members. So, Professor, you have the floor.
Good morning, and thank you very much, Professor Sumra. I trust that everybody can hear me. First, a quick thank you to Martin and Andre and all others involved in the organization of the conference. As has been said before, I too am very sad that we did not have the opportunity to have these discussions in the beautiful Olomouc, but I'm grateful that the organizers persevered, specifically in light of the challenges that Andre had mentioned, and made it possible for us to proceed, notwithstanding what has been going on. It has been some time since I have felt the amount of pressure to be on top of my game as I have in anticipation of today, and this is obviously due to the quality of the participation in this event, with my fellow panelists on this panel being key examples, and also due to the fact that I drew very much on the work produced by many people who are participating in the discussions today in informing my own thoughts and opinion in regards to this idea of own force violations in regards to child soldiers. Just to speak to a bit of structure, I will use the first few minutes of my time to frame the relevance of the issue of own force violations in regards to child members. The more analytical part of my presentation will then seek to address the state of law in regards to such own force violations by first examining arguments regarding the structure and scope of operation of IHL as a regime of law, and then focus will shift to the individual normative level. This part of the discussion will focus specifically on the application of child soldier norms in the context of IHL. And finally, if time permits, I will explore the dialectics of active versus direct participation in hostilities in the context of the Rome Statute. I will be aiming for each of these sort of points of discussion to take about 7 minutes. Most people here are aware that Thomas Lubanga was the first person to be prosecuted by the ICC, and he was charged only with the crime of child soldier use, conscription, or enlistment. Now, for better or worse, this came as a result of trial strategy and not as a result of the scope of crimes that was supported by the evidence. As a result, during the course of the trial, evidence frequently pointed to Lubanga's culpability for other crimes, particularly sexual violence and sexual slavery committed against these very child soldiers of whose recruitment and use he was ultimately convicted. This failure of justice led to Judge Odio Benito commenting in her separate and dissenting opinion that by failing to deliberately include within the legal concept of use to participate actively in hostilities, the sexual violence and other ill treatment suffered by girls and boys, the majority of the chamber is making this critical aspect of the crime invisible. Invisibility of sexual violence in the legal concept leads to discrimination against the victims of enlistment, conscription, and use, who systematically suffer from this crime as an intrinsic part of the involvement with the armed group. I thus consider it necessary and the duty of the chamber to include sexual violence within the legal concept of use to participate actively in hostilities. Now, clearly this opinion rests on a broad interpretation of what amounts to active participation, and this is an issue to which I will return later. However, as a preliminary point, this reasoning appears to be motivated by a desire for justice for such outrageous sexual violence and is not supported by even a generous interpretation of active participation in hostilities. This issue could have been addressed better by a different trial strategy rather than molding the law to achieve a desired outcome. Judge Odio Benito's opinion provides an interesting antecedent to the charges later brought against Lubanga's compatriot, Bosco Ntaganda. Amongst other charges, Ntaganda was charged both with the use and recruitment of child soldiers, as well as their rape and subjugation to sexual slavery. Following the confirmation of these charges against Mr. Ntaganda, the defense filed a motion before the trial chamber challenging the jurisdiction of the court to prosecute the defendant for sexual offenses committed against child soldiers, essentially on the basis that war crimes may not be committed by members of an armed force against fellow members of the same armed force. In particular, the defense argued that the established framework of international law imported a status requirement in regard to the victim of the crime, and that status being limited to members of opposing forces, those particularly placed hors de combat and civilians. The trial chamber dismissed the motion on the basis of 5 points of reasoning. The trial chamber addressed the issue both in the context of the law of international as well as non-international armed conflict, as the character of the armed conflict could still be differently determined as the trial progressed. We now know that the conflict was ultimately determined to be non-international at all relevant times to the charges. I'm not going to discuss in much detail the trial chamber's reasoning, but I'll just touch broadly on the 5 points that were made. So the trial chamber examined the structure of Article 8 of the Rome Statute and determined that the structure is broad and the chapeau is broader than simply that determined by grave breaches provisions and common Article 3. It acknowledged that most prohibitions of rape and sexual slavery in IHL relate to those who are hors de combat and civilians, but it was concluded that such explicit provisions do not limit the scope of protection from such conduct. It determined that such a restrictive approach to rape and sexual slavery is incompatible with the aims of IHL. It further determined that both sexual slavery as well as rape in the context of armed conflict amounts to a jus cogens violation. And finally, the trial chamber determined that Article 75 of Additional Protocol 1 in fact applies also to members of armed forces. The defense appealed this decision, and the appeals chamber likewise dismissed the appeal, holding that the applicable provisions of Article 8 did not present a victim status limitation. In other words, the victim need not be a person hors de combat or a civilian. And there is no general rule excluding members of armed forces from the protective reach of IHL as a regime of law. Now, these decisions received a mixed reception. Commentators were either strongly opposed or strongly in favor of the outcome. However, commentators have agreed that both chambers' reasoning lacked detail. For a number of reasons, this is to be expected in the context of such decisions, though. There is thus a need for further examination both of the conceptual issues regarding armed force violations, as well as the normative issue in regards to child soldiering. Now, this need for further examination is demonstrated by the contrasting view of the Special Court for Sierra Leone in regard to armed force violations. In the RUF case, the Special Court held, and I quote, "The law of armed conflict does not protect members of armed groups from acts of violence directed against them by members of their own forces," end quote. This finding came in response to allegations that the defendants were guilty of war crimes related to the extrajudicial execution of members of their own group. Interestingly, while the Special Court reached a contrary finding to that of the ICC, its finding was similarly labeled as superficial. I'm rather critical of the Special Court's finding in regard to this issue, and I should mention that my fellow panelist, Judge Winter, was the presiding judge in the RUF appeal. However, this issue was not appealed, and as such, my dissatisfaction with the finding does not at all extend to the work of the appeals chamber. In contemplating the protective reach of IHL, there is clear tension between notions of its broader structure and design and the potential of individual norms to define the extent of their application. So we often come across these broad sort of defining characteristics of IHL as a regime of law, and this speaks to, for example, that IHL serves to protect mutual interests of warring sovereigns reciprocally. Consequently, IHL is underpinned by the equality of belligerents, and IHL thus amounts, as Provost states, to standards of treatment or conduct rather than as rights of protected persons. On the basis of such characterization, a conclusion that IHL does not provide protection against armed force violence seems logical. Indeed, the view that IHL categorically does not protect individuals against armed force violence, such as what was held in the RUF case, is directly premised on such structural assumptions of IHL. However, clearly the above characterizations do not apply in the same manner to the law of non-international armed conflict. Moreover, some of these characterizations are contested. For instance, there is a growing body of scholarship in support of the notion that some norms of IHL confers individual rights. Moreover, whether indeed a given norm does so, it is suggested, is to be determined by way of the content of the given primary norm and not notions or assumptions of the broader character of the area of law. Being characteristically ahead of the curve, Sassoli wrote in support of this already 2 decades ago. Now, this is not to say that there is no structural features of IHL as a regime of law, the most obvious example being that IHL applies to situations of armed conflict. However, this example further illustrates my point. The existence of armed conflict as a trigger for the application of IHL is often overstated. There are many norms, such as Article 36 of AP1 regarding development and acquisition of new weapons, that binds parties outside of the context of armed conflict. And this can only be determined by reference to the primary norm and not through assumptions of the structure of IHL. Moving back more to the context of own force violations, those like Heller who acknowledge that grave breaches can be committed against own force members who are placed hors de combat, meaning precisely anyone who is defenseless because of unconsciousness, shipwreck, wounds, or sickness, but who contests the conclusion reached in Ntaganda does so on the basis of an analysis of the applicable norms of IHL that prescribe rape and sexual slavery. On the basis of such analysis, they conclude that those norms do not, as a matter of the primary norm, apply to own force members who are not rendered hors de combat. In fact, Heller states categorically that each and every IHL convention applies only to those categories of individuals, i.e. people hors de combat and civilians. And my purpose with this paper is not so much to critique the approach of the ICC as it is to suggest a child-centered approach to the underlying question. As such, my view is that in part, the answer is to be found by reference to the relevant norm providing for child protection and determine the scope of protection they continue to offer following recruitment and use. A rather meticulous technical analysis of the given IHL norms is called for. For present purposes, a detailed examination of the child soldier norms in the Rome Statute is not required. As has already been mentioned, there is no direct restriction against own force violations in the Rome Statute itself. Instead, the issue turns on whether IHL is so restricted. Article 4.3c of Additional Protocol 2, which applies to non-international armed conflict, provides that children shall be provided with the care and aid they require, and in particular, children who have not attained the age of 15 years shall neither be recruited in the armed forces or groups nor allowed to take part in hostilities. In contrast, Article 77.2 of Additional Protocol 1, applicable to international armed conflict, provides the parties to the conflict shall take all feasible measures in order that children who have not attained the age of 15 years do not take a direct part in hostilities. And in particular, they shall refrain from recruiting them into their armed forces. It's important here to observe that the level of protection afforded in the context of non-international armed conflict is considerably more stringent than that afforded in international armed conflict. And this is a rather unique feature. Indeed, one of the concerning features of the development of IHL through international criminal tribunals is the conflation of law of international and non-international armed conflict. This may seem justified on the basis of the increased convergence of these bodies of law as a consequence of customary international law. However, this approach loses sight of the differing nature of the law of non-international armed conflict and has the unintended consequence that in areas such as child soldiering, the more stringent protection offered in non-international armed conflict is watered down in the recognized customary norm to that recognized in the law of international armed conflict. In fact, and as an aside, it's important to guard against treaty norms as well as the codification of customary international law having a chilling effect on the actual development of customary international law. Indeed, the use of children for direct participation in hostilities serves as an excellent example. Almost all sources suggest that the customary standard is that children younger than 15 may not be used for direct participation in hostilities. And I'm emphasizing direct participation as distinct from forms of recruitment. However, every cursory examination of actual state practice and opinio juris on the issue of child soldier use, not recruitment, suggests that the appropriate age threshold in customary international law should now be recognized as younger than 18. Returning to child protective norms in the protocol, one has to look broader than the prohibition on the use and recruitment of children to gain an understanding as to whether children that are used in hostilities and or members of an armed group maintain any additional protection. To this end, Article 4.3d of Additional Protocol 2, again relating to non-international armed conflict, provides the special protection provided by this article to children who have not attained the age of 15 years shall remain applicable to them if they take a direct part in hostilities, despite the provisions of subparagraph C and are captured. Subparagraph C speaks to the prohibition of the use and recruitment of child soldiers. Now, this article has two possible meanings. First, it can provide for such protection only in respect of children who are captured, focusing on the last word. Alternatively, such protection applies continuously, including when children are captured. The latter interpretation appears correct in law, and should the provision apply only to those who are captured, it would be superfluous, as such children would in any event be protected in terms of Articles 4 and 5 of Additional Protocol 2. This is as a result of the wording of Article 5.1, which provides, in addition to the provision of Article 4, the following provisions shall be respected as a minimum with regard to persons deprived of their liberty for reasons related to the armed conflict, whether they are interned or detained. Additionally, the words shall remain applicable to them in Article 4.3d is indicative that at no time does such protection cease to apply. I should add that the 1987 commentary further supports this conclusion. Now, the special protection includes that children shall be provided with the care and aid they require, and the commentary in this regard states that this includes, in the territory under their control, the authorities, both de jure and de facto, have the duty to protect children from the consequences of hostilities by providing the care and aid they require, preventing physical injury or mental trauma, and ensuring that they develop as normally as circumstances permit. Undoubtedly, commission of sexual violence violates the duty to provide such care and aid. Now, moving on to international armed conflict, Article 77 of AP1 provides, children shall be the object of special respect and shall be protected against any form of indecent assault. The parties to the conflict shall provide them with the care and aid they require, whether because of their age or any other reason. And paragraph 3 provides, if in exceptional cases, despite the provisions of paragraph 2, children who have not attained the age of 15 years take a direct part in hostilities and fall into the power of an adverse party, they shall continue to benefit from the special protection accorded by this article, whether or not they are prisoners of war. Article 77.1 raises the question whether it ceases to apply to a child who is indeed participating directly in armed conflict and remains to be a member of the relevant armed group. While this may go against conventional wisdom, nowhere in Article 77 or elsewhere in the Geneva Convention regime is the applicability of Article 77.1 in such circumstances restricted. Article 77.3 uses the words continue to benefit from the special protection, which again suggests that such protection was never lost. This interpretation is also supported by the 1987 commentary. Rather oddly, it is the commentary to Article 4.3 of Additional Protocol 2 that makes reference to Article 77.1 of Additional Protocol 1 and then clarifies the meaning of the commentary to the latter article by providing that the weaker protection against use and recruitment offered by Article 77.2 of AP1 leaves the door open to exceptions which justify the provision that if children under 15 nevertheless participate in hostilities, they still continue to enjoy the special protection laid down for children. This is unambiguous. Moreover, Article 77 provides a rather clear example of the recognition of an own force violation. Should a person be recruited by a national armed force in contravention of Article 77.2, that amounts to a violation of IHL. Should that recruit, who is then a member of the armed forces, be used for direct participation in hostilities at a later date, such use is a separate violation of IHL. Yet at the time of the second violation, the victim is undoubtedly a member of armed forces and thus not hors de combat or a civilian. I have to emphasize that my conclusion that the child protective norms of both protocols continue to apply to children after they are used in hostilities and maintain membership of an armed group is not in conflict with the fact that such children lose protection from being targeted by opposing forces for such time that they directly participate in hostilities or maintain a continuous combat function. This is because the obligations in respect to the special protection of children under Articles 4 and 77 of the two protocols applies, and this is per the 1987 commentary, only in the territory under the parties' de jure or de facto control and not to children that fall outside of the control, such as members of opposing forces. There is one last issue I would like to explore, and that relates to the practicalities of the charges in Ntaganda. For the sake of clarity, this final point of discussion does not build on the previous discussion, where I've reached the conclusion that I indeed believe the child protective norms under both protocols continue to apply to child members and protects them from armed force violations. There has been much debate of the ICC's embracement of active participation in hostilities as a standard against which to determine whether children were used unlawfully in hostilities. Traditionally, the standard of direct participation in hostilities is of fundamental importance, as this is the standard that allows the principle of distinction to be operationalized in respect of fighters who do not have the status of combatants. Yet at the same time, it is the standard that determines whether a child is unlawfully used in international armed conflict. There's a vital balance to be maintained. A liberal interpretation of direct participation in hostilities allows for more children to be protected, but also for people participating in hostilities to lose protection from being targeted more readily. This approach also means that as soon as and for such time that a child directly participates, they lose protection from being targeted, including for the duration of occupying a continuous combat function. Now, there's an interesting history to the dual use of terminology, i.e. the active and direct participation of hostilities. The Geneva Conventions refer to active part in hostilities. In contrast, the additional protocols refer to direct participation in hostilities. However, the equally authoritative French texts of the conventions and protocols uses consistent terminology in this regard. Thus, the conclusion that direct and active should be deemed the same is justified, and indeed, until such time that the ICC diverged, the dominant view was that these were in fact the same standard. However, the ICC has maintained the position that direct and active are distinct standards, and that indeed active participation in hostilities includes a level of participation more removed from hostilities than direct participation. What is important is the Rome Statute still uses direct participation in hostilities as the standard to determine whether a person is lawfully targetable, but then shifts to a different standard of active participation in regard to determining whether a child is unlawfully used in armed conflict. This has the implication that a child can be used for active participation in hostilities, but never lose protection against attack, because that level of active participation never reaches the threshold of direct participation in hostilities. And this possibility has significant implications in regard to the consequences of membership to an armed group. The ICRC interpretive guidance on the notion of DPH provides that a fighter will be regarded as being a direct participant in hostilities and thus lose protection against attack for such time that they maintain a continuous combat function. This is relevant to the Ntaganda matter, as child soldiers forming part of Ntaganda's forces may have been regarded as having such a continuous combat function. However, the actions of the fighter still have to reach the threshold of direct participation at some point to trigger the loss of protection, which is then maintained for the duration of the continuous combat function. Ntaganda's argument was based not on the active participation in hostility standard as contained in the war crime of child use, but instead on the binary understanding of whether someone is a civilian or loses such protection by virtue of direct participation in hostilities. Thus, in terms of the court's jurisprudence, it's entirely possible for a party to be guilty of using children for active participation in hostilities, while the children in question were never direct participants in hostilities, which then means they were never members with a continuous combat function. Therefore, the Rome Statute standard for the child use offense will be met, but the relevant children will not lose protection by virtue of DPH. Moreover, the structure of non-state armed groups in non-international armed conflicts is such that an affiliation to such a group, such as being a cook or collecting firewood or water, can surely not be regarded as amounting to a form of membership of the group with the consequences of losing IHL protection. The implication of this is that the charges in relation to the enlistment, conscription, and use of children for active participation in hostilities on the one hand, and those in relation to the rape and sexual slavery of the same children on the other, are to be assessed independently. Should the court determine that indeed children were unlawfully used for active participation in hostilities, a separate inquiry needs to be undertaken to determine whether that use for active participation went further, reaching the higher threshold of direct participation, resulting in the loss of protection and in the child occupying a position of membership in the group. If it does not, then charges in relation to the use of children as well as their rape and subjugation to sexual slavery can be sustained without the need to take a position on whether IHL protects and force members from violence. Okay, that brings me to an end. Thank you very much, and I look forward to the discussion.
Thank you very much for your contribution. So, dear colleagues, I think that now I will pass the word to the final speaker or commentator of the first panel with Professor Klaus Kress. Let me introduce Professor Kress. Also, I think that he is well known to most of us. So, he's Professor of International Law and Criminal Law. He holds the chair of German International Criminal Law, and he is the director of the Institute of International Peace and Security Law at the University of Cologne. His prior practice was in the German Federal Ministry of Justice on matters of criminal law and international law. In addition to his scholarly work, comprising more than 150 publications on the law on the use of force, the law of armed conflict, and international criminal law, he has been member of Germany's delegation in the negotiations regarding the International Criminal Court, the Rome Statute, since 1998. Klaus Kress is also co-editor of several law journals, including the Journal of International Criminal Justice and the Journal on the Use of Force and International Law. He is a life member of Clare Hall College at the University of Cambridge, member of the Academy of Sciences and Arts of North Rhine-Westphalia land, and the recipient of 2014 Sheriff Bassiouni Justice Award, as well as of honorary doctorates from State University Tbilisi and the University of Huánuco. He was a guest professor at Columbia University Law School and Melbourne Law School. In 2019, he was appointed ad hoc judge to the International Court of Justice in The Hague. In this capacity, he participates in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, Gambia against Myanmar. So now I will give the floor to Professor Klaus Kress, who will present us some comments on the three previous contributions. So, dear Professor Kress, dear Klaus, with the floor.
Thank you very much, Pavel, for this very kind introduction. And first of all, my gratitude to Andre for giving me the honor to be included in the list of interveners in this conference, which we can already say by now, not only promises to be very interesting, but has proven to have begun very interesting. I'm also happy to see many familiar names, not invariably faces, because there are black boxes, but one face I see, Peter. It is very, very good to see you after many years of negotiating together. I think what this first panel has shown so far, and clearly shown, what an excellent choice in terms of topic you have made, Andre, you and your co-conveners. It is such a multifaceted notion that we have the opportunity to look into. I did not have the benefit of any paper or draft paper to look upon, so it was not possible for me to prepare in advance comments. I have just been listening with as eager interest as probably all of you to the brilliant presentations we had. And so what I will offer are some humble observations on what we have heard, a little bit improvised necessarily, and perhaps sometimes also more observations than comments directly related to what we have heard. When I said multifaceted, this topic, I think this is the fact because at least on five levels, this topic is so significant. There is, I would call those 5 levels, there is a general significance, a structural significance, a sources significance, a doctrinal significance, and then this specific victims perpetrator dilemma significance, which I think has also come out clearly from various of the contributions. And let me perhaps structure my observations a little bit along the list of those 5 levels that I have just alluded to. As regards the practical significance, I thought it was very impressive to have been reminded by Judge Winter of the sheer degree of relevance in a number of conflicts. And from my own encounter, I can recall we have a film producer here in Cologne, my home city, who produced one of the important movies on child soldier use in Uganda, the Lord Resistance Army's use. And this film left quite an impact on me because it made so visible the personal suffering of the victims concerned. So in a sense, child soldiers are part of a process in the development of international humanitarian law and international criminal law, as I see it, to make more visible than at the inception certain groups of particular vulnerability. We have perhaps seen a shift of emphasis with regard to the victims of sexual crimes, in particular female victims, in the work of the ad hoc tribunals, the Yugoslav tribunal, and then it was probably the Sierra Leone tribunal that, that stands for placing children also in or at the heart of public visibility. And the choice made by the first prosecutor of the ICC to place this crime at the heart of the first proceedings can be seen in that line. Reference was made to Judge Odio Benito's opinion in Lubanga, and here you can even, in a sense, see a struggle about competing claims to visibility. There was a sense, probably, Mr. Washford, I think you alluded to it, there was probably a sense Judge Odio Benito felt that the sexual component, the sexual crime opponent, was a little bit brushed aside undeservedly. And then, as you said, the doctrinal question, however, was whether you could remedy this by somehow squeezing the boundaries of the crime's definition. What I mean by structural significance, this was one of the topics, Mr. Washford, you have placed your emphasis on, and I thought in a very sophisticated manner. This fascinating effect of what you call own force violations, or you could also speak of intra-party violations. And indeed, it raises a fascinating question. I recalled when listening to you, Ted Meron's landmark article on the humanization of international, on the laws of war that probably most of you have read. I think humanization as such is a tendency that nobody would really disagree that it has happened. The question is to what point we have come. And here we have perhaps a specific facet of humanization. Humanization can mean that human rights law informs rules that still apply at an inter-party level. But here we move one step beyond, by using your term, and move to own party violations. There are, I think, two questions that you have risen for further, or you have given us for further reflection. The first question is whether perhaps we are experiencing here a certain divorce between Ajax and Najax. So is there an argument to say that perhaps the law of non-international armed conflicts is more amenable to capture own force violations, which would lead to the interesting results that while hitherto we have thought that the law of international armed conflict is the more comprehensive body of the law, we are now facing a somewhat contrary trend. And the second question, I would love to hear your view about it, Mr. Washford. We can, and I think under the existing law, we still have to treat own force violations as rather the exception from the general structure of the law. In your view, as a matter of policy, should the structure, the peculiar structure of child soldier offenses be taken as a basis for further generalization, or should we be rather cautious? Third level of significance, sources. Judge Winter, and it's really a pity that she had to leave, she has alluded to this core point about the customary law basis, and I'm very pleased that she focused the need for a customary international law basis, because there is a certain tendency to water down international criminal law stricto sensu and to just be content of a certain conventional basis. But very rightly, I believe, the Sierra Leone court has taken care to make sure that this crime is rooted into general customary international law, so that the claim that this is a conduct that offends the international community as a whole is really warranted. But then the problem, and that's one of the key problems of the entire development of international criminal law, how to precisely identify a crime of customary international law. Peter, you have stressed this distinction between primary and secondary norm. And I don't think that it's just the Czech scholarship that is placing emphasis. I think it is a question that has been haunting the history of international criminal law from its inception. This afternoon, we will be celebrating in my University of Cologne the award of an honorary doctorate to Benjamin Ferencz, which will take us back to Nuremberg. And as everybody of you recalls, it was the main defense put forward by those defending the German perpetrators, the German criminals, that while wars of aggression were clearly prohibited at the time under the Briand-Kellogg Pact, there was still no, as you call it, Peter, secondary rule. I found it fascinating to get a glimpse of the methods that Judge Winter had applied by looking into national legislations. I would have loved to put an additional follow-up question to her. In what precise methodological way she has done it? Has she looked for a kind of basis in terms of general principles of law, a basis in the national legislations, which is more or less similar, or rather as a indication of an opinio juris of those legislating states that the conduct is criminalized under international law? Whatever the precise methodological approach chosen, I think Sierra Leone has been one of those, I would call them crystallizing points. The development of international criminal justice is marked by a number of crystallizing points. We have major crystallizing points and more specific ones. Of course, Nuremberg was a major crystallizing point. I would consider the Tadic decision as a major crystallizing point for non-international armed conflicts, for the emancipation of crimes against humanity as a crime, as a separate, autonomous crime under international law. And Sierra Leone stands for a more specific crystallizing point related to the crystallization of those crimes with which this conference deals under custom. And probably the question now has become much less of a burning practical need, because in a sense, the Sierra Leone precedent has been accepted by the subsequent practice, so that the customary status has consolidated. Doctrinal significance, of course, here you could hold an entire conference on those many aspects, and I will not even start to do justice to them. Perhaps in addition to the points Mr. Washford has alluded to, Judge Winter related to the huge practical problems in establishing the age of the alleged perpetrator. But there are, as you know, complementary legal issues, especially with regard to the mental element as regards the age. The elements of crimes relating to the ICC statute have introduced a negligence status as to the age. Is this in line with Article 22, with the role of the elements of crimes under Article 9 of the ICC statutes to just elucidate the judge's interpretation, but not to go beyond, not to amend the law? One question. A second question that I find intriguing, if and to what extent those crimes can be characterized as continuing crimes with all the, for example, jurisdictional problems involved. But on your point, Mr. Washford, which is at least one of the most fascinating ones, and perhaps from the angle of the interplay between international humanitarian law and international criminal law, it's the most burning one. Making sense of the subtle distinction between active and direct participation, between protection under international criminal law and loss of protection under the targeting rules of international humanitarian law. Perhaps if you could just, if you have time, or if you would be kind enough to take the floor again, if you would emphasize to what extent you think this approach to distinguish between the two notions in view of the different purposes, criminal law protection, loss of protection, to what extent you think this is convincing, or whether you also see dangers. Last level I want to allude to, victims and perpetrators. It's situated on the borderline of legal sociology, on criminal law theory, what and how to deal with those persons where the borderline between victimhood and perpetratorship becomes a very fine one. And indeed, in that sense, again, Andre, this conference is so timely with the recent Ongwen decision, which, as one of the participants in the chat has already made clear, is a paradigm case for this problem. Just perhaps few remarks to conclude. First of all, I cannot help saying how moving this example was Judge Winter has given us. This example of this young human person in this prison being portrayed as a genocidaire. My sentiment is that the Sierra Leone tribunal made a wise choice to say at the outset that whatever judgment you reach on those young people, they are certainly not among those most responsible where the exercise of jurisdiction of this ad hoc tribunal should focus. I recall the negotiations on the ICC statute. Peter, I'm not sure whether you took part in that discussion directly when the discussion came up about Article 26 of the ICC statute to limit the ICC's jurisdiction to persons having reached the age of 18. And then there was a question whether we should include specific provisions about juvenile offenders in the ICC statute, which in the end was left out. And we settled with this rigid rule. A question perhaps also in the context of this conference to be discussed: was it a wise choice? In a sense, following the Sierra Leone logic that it is very unlikely, to put it mildly, that persons below 18 will ever come within those allegedly most responsible? Or would it have been worthwhile, perhaps would it be worthwhile for future deliberations to come up with a set of rules for juvenile offenders designed to international proceedings, perhaps only with the beneficial collateral advantage that this could have an influence on national laws, national legislations. Mr. Chair, Pavel, I think I should leave my tentative observations here.
So thank you very much, Klaus, for your extremely inspiring observations and comments. And now I think that during the first round, I would give the floor back to our three, or actually now Judge Winter has left, so two other panelists, and then I will open a general debate. So I think that now it is up to Peter and Gus to respond, to react, and then I think everyone is invited to raise the hand and ask questions or some statements. So who would like to start? Probably Petr Válek first.
Yes, I would like to first of all thank Klaus for these insightful comments that I really enjoyed. Since I would like to leave more time for possible questions by others, I would like to comment just on 2 points. Yes, I mean, primary, secondary norms distinction has been also used by the International Law Commission. I mean, the remark that I made was that this distinction has been very important for the Czechoslovak science of international law. So I was not trying to claim that this is our let's say, exclusive thing. And yes, you are completely right that the first dilemma was already in Nuremberg, but for the time restraints, I obviously had to cut down my statement. My final remark is on the sources, and that is really, I mean, you touched upon a few issues. You know, the issue of sources in international criminal law. You know, we have treaty law, we have customary international law, and I think now as a practitioner and also as a lawyer coming you know, from the civil law system, that you know, the treaty law basis is always more solid. And if you look at the application of international customary law in international criminal law, there are always, you know, different views, debates. I mean, was it really a rule of customary law? Do we have the usus longus, opinio juris of states? I mean, if you look at the trials, not after World War II, not just in Nuremberg, but the trials by the military courts of the UK, of Canada. Let's say they worked with customary law in a relatively flexible way. So, my general remark would be that the future of international criminal law is with treaties, with the Rome Statute, and with the ICC that leaves very little space for speculations and debates on criminal responsibility in this or that case. Thank you.
Okay, thank you very much. Thanks, Professor Kress. Firstly, it's very good to meet you. I've never met you before, and I thought this is a good opportunity for that also. So thank you very much for raising really such interesting topics that I regret having spoken so long, because I would have liked to have some more time to comment on many of the themes that's been put on the table now. So I'll do my best to get through the few comments that I do want to make relatively quickly. I think one of the interesting things that were mentioned is this sort of making visible the issue. And it's interesting, Peter highlighted the rapid development from 1949 to 77 in creating treaty norms prohibiting the use and recruitment of child soldiers. But what's interesting is after 77, not much happened for a long period of time. In 1996, Graça Machel, she was appointed, I think, in 93, 94, and she tabled a report to the UN in 96 on the effects of armed conflict on children more generally. And then she highlighted this issue of child soldiering very centrally. And to my reading, at least, that became sort of a catalyzing moment for this extraordinary amount of attention that came to be placed on this issue of child soldiering, then also leading on to the special court and it exercising jurisdiction in that regard. So I think it's interesting, speaking about these sort of crystallizing moments outside of formal development in ICL. I think that report was such a moment in the broader sense. Moving on to my sort of terminology of own force violations, which is certainly not a technical concept at all. It just sort of rolls off the tongue a little easier for me than intra-party. It's an interesting point that was raised regarding the sort of divorce between international and non-international armed conflict. And Ryan Goodman, for example, has made this argument that the law of international armed conflict in his terminology creates an outer boundary of permissibility for the law of non-international armed conflict. So he basically suggests that everything that is prohibited in non-international armed conflict is equally or more greatly prohibited in the context of international armed conflict. And there's a problem with that because there's a few exceptions. And the protection of children from use and recruitment is one such exception. So as soon as you buy into that argument too strongly and you start interpreting really what the law of NIAC is through the lens of what the law of IAC provides for, then you run into that trouble. And I think this is done too readily for a lot of practical reasons, of course. If you look at something like military training, it's not feasible to train soldiers both in the context of the law of non-international and international armed conflict. More often, a more sort of generalized interpretation of the law is provided for. But these nuances, I think, should not get lost in that discussion. Sorry, just moving on. So this sort of active versus direct participation approach that the ICC has taken, I think the question was quite directly there, is it convincing? And I don't think so, in my own view. In fact, I did my PhD on child soldiering, and between the PhD being submitted and me sort of finalizing the manuscript for the book, much of the Lubanga judgments came out in that period. And all of a sudden I had to rethink and redo much of the writing on active and direct participation in hostilities. And just to mention, it's quite interesting that both in the Akayesu case, but also in the jurisprudence of the Special Court for Sierra Leone, the approach was relatively consistently taken that these sort of standards of direct and active amount to the same standard. I think in Akayesu, something was said to the effect that it's sort of semantics in language, the difference between the two. In the ICC context, it really came from an earlier report where there was this reference to active participation in hostilities being a broader concept. That was initially the point of reference to develop this idea that it's broader, at least in my reading. And I don't think that's very convincing, but I also think it's leading to a number of practical problems, as I try to set out in part of my presentation. And then there's just two more things that I quickly want to take the opportunity to speak to, and I don't want to occupy too much more time. I think the one is an interesting point that was made towards the end regarding the Sierra Leone tribunal having the potential to exercise jurisdiction in regards to people aged between 15 and 18. And then, as you said, David Crane saying early on that he will not seek to prosecute children for having been forced to commit crimes. He will prosecute people who force children to commit crimes. What I find interesting there is, I think the underlying idea of the kind of jurisdiction that was provided for ratio personae in terms of those aged 15 to 18 was good in nature. But I think it required more thinking. So I think really a separate procedure and a separate mechanism would be required to give that kind of sort of rehabilitative element to justice that was envisaged with that form of jurisdiction, which perhaps an international tribunal is in any event not very well capable of delivering ultimately. And then the last point, I can't resist but to speak to the Sam Inga-Norman interlocutory appeal that was mentioned by both the other speakers in the context of this panel. This is a decision that I've written on quite a bit, and I'm very much falling into the camp of Jeffrey Robertson with regards to opinion as to what the outcome of that legality question at that stage should have been. And I think I just want to emphasize, and this is why I'm bringing it up, that it's very much as a result of the technical legal nature of the way the crime was formulated. And it's one of those cases where a strategic mistake was made, at least in my view, in the way the crime was formulated in the statute of the special court. And there's a strange history to this, because actually an earlier draft of the special court statute did not have this formulation, their own statute formulation of the child soldier use and recruitment crime. It was framed completely differently. And there's no sort of documentary suggestion exactly how this change came about, but ultimately the Rome statute crime was adopted. And as Peter mentioned, the temporal scope of jurisdiction predates the Rome statute formulation of the offense. And I think that was the crux of the problem there. So yeah, I think I've spoken to everything that I think I was specifically asked to, and some more. Thank you for that.
Thank you very much. So I think that also I would use the opportunity that I can say a few words, and then I think we will be able to open a general debate. I think that there are two quite interesting aspects, in particular arising from the comments by Professor Kress and Dr. Válek. One is about treaty law and customary international law as sources of international criminal law today, and the other, the favorite issue of primary and secondary rules. I think that we do need both treaty law and customary international law in practice, but I think that their role is somehow evolving, and I would say that maybe we are moving from the period of crystallization of customary law in certain aspects of international criminal law to the times of codification, and maybe next also interpretation of the codified rules. I think that in 1990s it was definitely the period when the international criminal law was not developed too much in some respects, and then it was a quite interesting process of crystallization of certain customary norms, also thanks to the activity of the ad hoc tribunals. But with the adoption of the Rome Statute of the ICC, I think that many rules have been codified in the form of treaty, and I think that in principle, and I think that it was also the intent of negotiators, and I personally took part in the Rome conference, that the intention was also to some extent limit the freedom of the ICC when it comes to the use of sources, because we have the list of sources to be applied by the ICC. Of course, it doesn't prevent the court from very important role when interpreting the existing rules, treaty rules, and applying to some extent where necessary customary rules of international law. And I think that the problem of primary and secondary rules is also quite interesting, and it recalls me the online conference we organized last October in Prague, and Professor Kress also participated to our conference dealing with the crime of genocide then and now, and we are now preparing a publication book based on this conference. And I think that it also has certain impact on the interesting question of, let's say, dual responsibility. On the one hand, international individual criminal responsibility, and then the state responsibility for the, let's say, a crime of genocide as a famous example, but even crimes against humanity. When adopting draft articles within the International Commission, we also discussed one provision which should make it possible, or at least not to exclude, the responsibility of states in addition to individual criminal responsibility. And then, of course, the conditions for individual criminal responsibility are not necessarily the same. There are some differences from the conditions of state responsibility. And then still I believe that we have the same crime, the same prohibition of genocide, the same prohibition of crimes against humanity in both cases as a matter of primary rules, but it does not prevent us relying on slightly different rules and conditions for establishing state responsibility or individual criminal responsibility. But it was just the comment from chair, and now I would not misuse my authority any longer, and I will give floor to participants for questions and comments. So I think that you can simply use your hand or the facility of Zoom to show your interest to intervene, to ask questions, or to present some comments. So who is first? Okay.
Maybe Pavel, since I don't see any questions at this point, I have just one more remark. On the sources. This is the debate opened by Klaus, and you follow up on this, saying that we need both customary international law and treaty law. Yet I would still push my point that the future is with the treaty law, and I would argue that the work of the body that you are still the chair of, the International Law Commission, actually is my argument, and I think that there is one document that should be mentioned as a part of this debate, and this is the Convention on the Crimes Against Humanity, which is, we have the ILC draft, and now, we have a critical mass of states in the UN that want to push through this convention. We also have a few states that do not believe that this convention is necessary. But I think that these efforts and the support for this convention, I think it shows that there is a demand among states for treaty law in this particular field of international criminal law for the reason of legal certainty and clarity.
Yeah, thank you. I agree, of course, and I also try to push states during the sixth committee in New York, actually not last year, but in 2019, when I presented a report from the International Law Commission. And of course, I know that there is a growing support for articles and future convention on crimes against humanity. I think that, yeah, of course, one reason I agree is for greater certainty of written rules, treaty rules. And I think that in addition, and this is again the difference of obligations, that we can maybe rely on let's say customary definition of crimes against humanity, however codified in the Rome Statute. So it is not just unwritten, but it is a treaty law. But when it comes to additional obligations, how the state should act in order to prevent and punish those crimes, I think that this is only possible to ensure by way of multilateral convention. Criminalization, establishment of national jurisdiction, extradition, and other obligations written in the draft article. So I think that for many reasons we should rely on international treaties in the future. That's true, and I think that the fact that still we refer from time to time to international customary law, it is all because I think two facts. First, some states are not or will not become parties to certain conventions, and that's why it is good to recall that certain obligations are here even as a matter of customary international law. Second is that there are also certain non-state actors which by definition cannot become parties to existing or new conventions, but still we want them making responsible, or the members of such groups making responsible in case of violations of the fundamental rules, war crimes, crimes against humanity, etc. So I think that this is maybe the reason why we should still keep in mind the customary law, but I think that definitely for future I would also agree that we should rely more on treaty law, and of course the important role of lawyers and in particular judges is interpretation of treaty rules. And then I think that it will be probably more interpretation than creation of new rules. And if it's the case, I think that probably we both will be happy with such a development.
I'm sorry to interfere. We just have two comments or some comments also in the chat. So if I could ask Professor Sturma just to give floor to Sergey and to Roger, since not everybody has the possibility to raise hand and ask questions.
Yes, yes, please. I think that this is good, and yes, I would like to give the floor to them. So please, you should repeat or write your questions. I think that one is from Serge Massol, and the other is from Roger Bartels. So maybe the Roger first, and then Serge Massol.
Hi, good morning. Yeah, sir, this is Roger. I had a comment that I put in the chat, but then well, whilst typing, Sergey put a comment in between. So my question that related to the comment only appears underneath. The issue in relation to the humanization, Professor Kress raised the interplay between, well, how the interplay between international humanitarian law and international criminal law is shown by the active participation, direct participation question and the loss of protection related to it, how Gus addressed that in his presentation. And this links to the clash, as I've referred to it in my writings, between the two different presumptions that underlie these two different bodies of international law. So on the one hand, you got international humanitarian law, which has the presumption of protection. In case of doubt, you have to assume someone is a civilian, is entitled to civilian protection. In case of doubt, whether a building constitutes a military objective or is protected as a civilian building, you have to assume it's still protected as a civilian building, and same for POW status. So there's this general presumption that someone is protected unless you really have certainty as to the status otherwise, or intelligence that can tell you the status of a person or a building. Whilst under international criminal law, which is of a branch of public international law, but it is, of course, criminal law, you have the presumption of innocence as the core principle of core presumption of criminal trials. And when it comes to the loss of protection, this clashes directly. This came to the fore in the Galić case, and this was then, they came up with this threshold that the prosecution have to prove that a reasonable person could not believe that the person attacked was a combatant, despite them not having actually said it was an IAC in that situation. But now recently in Nataganda, they modified this into that a reasonable person could not have believed that the individual or group he or she attacked was a fighter or directly participating in hostilities. So you have to assume for protection that the loss because of participation in hostilities that's a high threshold. It has to be under IHL, because you don't want that person to easily lose his or her protection. Yet under ICL, you have to assume that in case of targeting, a question of targeting, that person has actually lost his protection because of the principle of innocence. You see the two presumptions clash here. But then you get this interesting thing which Gus addressed, that of course, because children can be targeted and have kind of their protection issue there, but they also have their protection against being recruited and against being used in hostilities. So here there's almost kind of a reverse again of the clash between these two presumptions. And whilst it works in the one way when the child would be targeted, it works in the other way when the child would actually, when it comes to the use of the child in hostilities. And so that I wanted to raise that this is such an interesting interplay between these two bodies of international law. But then my question that follows from this is to Gus, because he highlighted how under the law of Nyack, a child has more protection under IHL, but that then under international criminal law would seem to imply that you can't too easily assume that there's a Nyack, because this actually has repercussions for the accused. put on trial, which then again raises the question about the status or the classification of the conflict, which in Lubanga was such a big issue, of course, where the pretrial chamber initially said that it was an international armed conflict, and this was then contested by the prosecution, and ultimately it was found to be a non-international armed conflict, which would seem to make it easier to find an accused guilty because of the higher protections under IHL. So yeah, this specific issue and the view as to which law is more protective and how that works then under international criminal law, not under IHL, which Gus clearly addressed, but how in his view it works under international criminal law. I'd be happy to hear some further thoughts on.
Okay, thank you for the question. I will collect, I think, like 3 questions, and then I will give a chance for answers. And the next one is Sergi Massol. Please, you can ask your question now.
Thank you. Do you see and hear me now?
Yes.
So I would like to thank all the panelists and the commentator, Professor Klaus Kress, for the wonderful presentations and discussion. And in his comments, Professor Klaus Kress mentioned the idea of humanization of international humanitarian law and international criminal law developed by Theodor Meron. And does any of the panelists or Professor Kress think that any of the chambers in the case of Lubanga, except for the futile attempts by the dissenting judge Odio Benito at the trial stage, has managed to humanize the relevant statutory framework related to child soldiers? In my latest article that will be published actually this week, hopefully tomorrow, I argued that the role of international criminal law and humanitarian law was decisive in the Lubanga case. References to human rights law in that case concerned essentially 4 different topics. First, the distinction between forcible or voluntary recruitment of children. Second, the age of children. Third, the nature of an armed group. And fourth, the question of active participation in hostilities. However, all these references to human rights law, as I argue, merely confirm and legitimate the conclusions reached by various chambers on other grounds, rather than humanize the definition of the war crimes of conscripting and enlisting children under the age of 15 or using them to participate actively in hostilities. So at the end of the day, the mundane solution of bringing specific sexual violence charges by the office of the prosecutor in the Ntaganda case appears to me to be a more realistic, down to earth and compliant with the principle of legality, rather than a creative human rights based and victim centered interpretation of the definition of the war crimes in question and their humanization. Thank you very much.
Thank you very much for the question. And the third one on the chat list is Mr. Alexander Galland. So now you can ask your question. Alexander.
You're muted, Alexander.
Mm-hmm.
Hi, I'm sorry. I didn't actually have a question. I was just pointing out that there were some issues with the raise your hand function. So maybe sometimes you can't see it. But now that you give me the floor, there's one thought I had in mind while hearing the exchange between, you, Pavel, Klaus, and Peter on the distinctions between treaties and CIL. And I'm wondering, I'm wondering whether the ICC, in the sense that it is simply interpreting the treaty and that the interpretation that it offers are most, if not only, for its own jurisprudence, whether it will have an effect on domestic jurisdiction is something that can be discussed. And I would like to hear your views, because there is some, as we know, through the principle of complementarity, there are some divergence on whether or not we need to strictly apply the crimes at the domestic levels, but also the interpretation of the court of its crimes. So when the court contributes to IHL through its jurisprudence, it has, I would say, relatively a slight effect on what domestic jurisdiction will do, while when we think of customer international, and in particular of the courts that were, so the tribunals, the SCTY, ICTR, SCSL, that were applying customer international, or at least saying that they were doing so, the effects was much greater at that level, given that customer international law is said to apply to all, and the words of these international tribunals were considered as greatly authoritative. So I'm wondering whether actually you see this difference, Peter, as you are exercising at the domestic level, and what you think of it, and whether it makes you rethink about the effects of treaties.
Okay, thank you for your question. And I think that now it's time to give floor back to our panelists and commentator. I think that maybe there is someone who would like to speak first.
I'm happy to go first if that's okay. Yeah. Roger, I hope I get to sort of the crux of your question well enough. So I think there's a few interesting elements that that comes to the fore. I think firstly, just to address the classification question, I don't think, and I certainly don't suggest that considerations of the extent to which a given underlying offense can be proven on the evidence should impact at all questions regarding classification of the conflict. So questions regarding classification should be dealt with on the basis of the facts related to the conflict in question. So to me, those two issues should not be, at all sort of, one issue shouldn't influence the other issue. In regards to your question regarding the sort of underlying assumptions of ICL and IHL, I mean, firstly, I think you're really the one that should speak to that point. But from my perspective, this raises in my mind, and it has for some time, this question about, are we going to see in jurisprudential development, obviously in the ICL context, because we don't have that development in IHL, but are we going to see a trajectory that sort of moves, that gets a life of its own, where reference in one case to previous jurisprudence reinforces the underlying assumptions of ICL more and more, that we get to a point where we can't really resemble interpretations of the underlying ICL norm to the corresponding IHL norm that well anymore. I mean, I'm not suggesting this is going to happen very quickly. It's obviously much more of an incremental process, but I, for one, think that that might be the way things might develop over time. There was another aspect to your question. I just want to sort of jog my memory by looking at your comments that I wanted to touch on as well. The question regarding the sort of interface between the IHL and ICL norms in regards both to NIAC and to IAC. So my suggestion is not that the norm in the Rome Statute prescribing child enlistment, conscription, and use should be interpreted differently than it exists in IHL. But certainly if we want to find what the customary status of the prohibition is in IHL, as sort of on the basis of the argument that the prohibition in ICL should be reflected as a violation in IHL, it's a different standard that we look to. And as far as the violation of the IHL norm in its own right, outside of ICL considerations are concerned, that's where I emphasize the importance of recognizing the significantly better protection that is afforded in the law of NIAC when compared to the law of IAC. And I just want to add, I think that also filters into this discussion about treaty law and customary law to a significant extent. And that's the sort of warning that I added into one part of my presentation. I'm sure I'm not touching on everything, and I'm happy to pick up the discussion with you later again, because I think it's very interesting. Moving on to Sergei's point regarding the Lubanga case, I mean, I don't think there's a particular need in all of the Lubanga jurisprudence to refer to extensively to international human rights law to bolster the ultimate underlying issue, because I think IHL provides for that adequately, and IHL is that vehicle through which we materialize war crimes. But what I do want to add to this is child soldiering, the prohibition of child soldiering, is conceptually a very difficult issue to locate adequately, either between human rights law or humanitarian law. And so much so that when for better, well, I say for better or worse, I think for worse, when the Convention on the Rights of the Child formulated Article 38, it adopted basically the exact language from Additional Protocol 2, which is the weaker of the two protective standards in in IHL. The only difference materially between those articles is that Article 38 of the CRC is addressed to state parties, reflecting the nature of human rights law, where Article 77.2 of Additional Protocol 1 is addressed to parties to the conflict, obviously addressing the character and nature of international humanitarian law. Now, this obviously makes for a fascinating space in which to further discuss the co-application and sort of overlap between human rights and humanitarian law, but it also makes for a number of challenges. Because when the additional protocol to the Convention on the Rights of the Child on the involvement of children in armed conflict came to be, it created vastly different standards of protection, or rather one should say standards of obligation, on state and non-state entities. And translating that into an application in armed conflict, which this convention, while being a human rights convention, is very much aimed at doing, you start encountering problems with issues such as equality of belligerents and so forth. Now, I don't think there's any concrete solutions to these problems yet, but I think that this overlap, the sort of gray area that child soldiering conceptually occupies in international law, is very interesting in that regard. And then lastly, Alexander's point, it's not really aimed at me, but I do want to chip into this real quick, if I may. I've been involved with some litigation regarding domestication of the Rome Statute in the South African courts, specifically on the basis of extraterritorial jurisdiction, in this case regarding crimes against humanity in Zimbabwe, committed in Zimbabwe. And I think that the answer to your question rests very much in the legal tradition of the domestic jurisdiction in question. So I would suggest that the South African jurisdiction would be very open-minded to interpreting ICC jurisprudence in formulating ICC crimes that are domesticated into South African law. And I say that on the basis that the Constitutional Court of South Africa has been very receptive of interpreting international jurisprudence in general terms in applying human rights law and other areas of law domestically. So I think, just to add this, I think it's going to be very much dependent on the tradition within the domestic system that you are considering. Thank you.
Okay, thank you. And I think that some questions were addressed to Professor Kress. So I will ask you to take floor.
Yes. Thank you, Pavel. Just a brief word on Roger's observations, which I find very, very precise and important as regards the different presumptions resulting from the different structure and logic of the different sub-bodies of law. Roger, this is sometimes, just to comment a little further, this sometimes creates disappointments in the general public if international criminal law cannot, so to speak, activate the full potential that might be seen as inherent in international humanitarian law, but it can't, precisely because of this own logic, which it cannot violate for the sake of maintaining its own integrity. And what you said about the three presumptions with regard the child soldiers offense is fascinating. I never thought about it that precisely, but I think you are right, and that adds to the peculiarity of the nature of that crime. I am inclined to agree with you, Sergei, although before I do it, definitely let me await the publication of your article, which promises to be very worthwhile reading. Thank you for alluding me to it. What I would like to use a little bit more time of is this debate that Peter has begun and Pavel followed on the basic sources question, custom and treaty. So first of all, Peter, I am in full agreement with you in two respects. First of all, the general tendency in international criminal law, and I stress in international criminal law also, is that treaty law, conventional law gets an ever more prominent place. In a sense, that was one of the core ambitions behind the ICC statute to give treaty law a more prominent place. And the second point, I agree with you, Peter, this is a very positive thing. I consider this to be an achievement. And I think not only, so to speak, civil law, socialized lawyers should consider that as a positive thing. I think also common lawyers should appreciate the enhance in legal certainty to the benefit of the global citizen, so to speak, which is implicit in the move to conventional law. So in that sense, I am in full agreement, and this avenue should be pursued by states. You have spoken about the Crimes Against Humanity Convention. I am among those who consider this a very important and positive step forward. And I very much hope that states will now take it up once the ISC has completed its tasks up to that point. Because far beyond the definition of the crimes against humanity, this convention could bring advantages. Just think of the competence of the International Court of Justice in borderline cases. Very important. But, and there comes the but, Peter, I believe we should be very careful, and especially also judges should be very careful in saying, well, a treaty law basis is enough. You yourself recalled, and I think very rightly, the point that at the Rome conference, the idea was not to create new treaty law, new conventional law. As you said, the idea, and there was, as I recall, almost a universal consensus, and Philipp Kirsch made this point very clear for everybody, was to codify, perhaps to crystallize here and there, inevitably, but to codify customary international law. And I think it is crucially important to keep that relationship in mind. So let us cherish the achievement by having a treaty law basis, but let us not cut the connection of this treaty law basis with customary international law. And this, I believe, not just for in terms of legal aesthetics, but there are practical problems involved. It does matter in many respects for the jurisdiction of the ICC, for questions of immunity. Just to mention two important aspects, whether a crime included in the ICC statute has a customary basis or not. And I think states must be very, very careful also when they amend the ICC statute. And they should, I think they should be explicit whether they hereby wish to codify or crystallize customary international law, or whether they would like to go beyond. And if they want to go beyond, they make a very important step, because then they create a so-called second universe of ICC crimes, pure treaty law crimes. And I just flag the point because it's not an inconsequential choice. Once you opt for crimes that are only conventional in nature, you will have follow-up legal questions. And I think legislators should bear those consequences in mind. This is all I wanted to say.
Thank you very much for your answers and comments. I think that now I have the floor to Peter before concluding the first panel. Peter.
Okay, I will have just a final remark on this sources dilemma and take it as a joke. You know, in reality, you know, the courts who establish customary international law, this is not just the ICJ, which that does it very responsibly, or ITLOS, or other international courts and tribunals, but these are domestic courts that find and establish international customary law. And sometimes, I mean, I will speak primarily about the Czech courts. in other areas of international law, such as the jurisdictional immunities of states and their property. I was really surprised, how the domestic courts, the Czech courts, found or didn't find customary international law. And sometimes I was very disappointed. So I would rather leave, the norm creation to us states, lawyers, and diplomats. But this is really a joke. And now an answer to the question that was, that was made at the end. Whether the ICC case law and jurisprudence would have some influence in the future on the decision making of the domestic courts. And here I would like to make 2 points. First, it's true that in Europe domestic courts don't deal that often with the particular crimes that are just so severe, like war crimes, genocide, crimes against humanity. So there are not that many occasions. And second, it also depends on the way of implementation of obligations arising from the Rome Statute. There are states that simply copied and pasted, the definitions of the crimes, war crimes, crimes against humanity. And there are states like the Czech Republic that created its own criminal code provisions that are of course very similar, but they are not the same like the ones in the Rome Statute. So I would say that at least in our case, the influence of the ICC on our courts would be relatively limited. But who knows? Since the Czech judge at the ICC, the first vice president of the court, Judge Fremer, will finish his mandate soon and will resume his post at the Czech Supreme Court. So maybe he will promote the jurisprudence of the ICC himself. Thank you.
So thank you very much. So, dear colleagues, I think that we are slightly over time reserved for the first panel. So let me congratulate, let me thank all panelists and commentator, Professor Kress. I think that we had extremely interesting debate. And then I think that it is not up to me to trying to summarize it. It would be extremely difficult, and I think that we don't have time for it. But I would like to remind what was already in the program, that the participants, panelists will present their papers, and then there will be publication. I think it will be very, very useful that all of us would be opportunity to read the rich contributions. And with that, I think that I could close the first panel. Now, according to the program, there will be lunch break. I think that it is not like in traditional conferences, we will not meet during a lunch break, which is a pity, of course. But anyway, it's up to us to search for and to provide some refreshment or lunches. But anyway, I think that the conference will continue in the afternoon and tomorrow. So I would like to say at this moment that the expectations of all of us are fulfilled based on the results of the first panel, but I wish also success to all other participants and panelists who will come in the afternoon and tomorrow. And with this, I will finish my responsibility of chairperson of the first panel, and I will pass the word to our organizers from Olomouc to tell us some organizational information. And I hope to see you later, preferably in person in Prague, or but by other means too. Thank you.
Thank you, Professor Sturma, and thank you to the panelists and also those who raised questions and commentated. Indeed, this was an excellent introductory panel. Indeed, as Professor Sturma mentioned, we have a lunch break, and so we would meet at 1:30, so in 1 hour and 15 minutes, when we will continue with the afternoon session. I'm looking forward to that. If you are going to have lunch, we wish you bon appetit, and see you in 1 hour and 15 minutes. Thank you.
Good day. I am Martha Bradley. I hope that everyone can hear me. Martin, can you hear me? Wonderful. I am Martha Bradley. I am a lecturer at the Department of Public Law at the University of Pretoria. And as a former postdoc of the Palazzo University, I'm especially delighted to chair this session on law finding, identification, interpretation, and application. I just want to ask if Paolo has joined us yet. No, so we will have the introductory words a little bit later on when Paolo Fara, the representative of ESIL, who is on US time, joins us. Just some administrative arrangements. Each panelist will have 20 minutes, after which there will be approximately 25 minutes allocated for discussion. I will now introduce our first speaker. Tamas Hoffman, PhD, is a Senior Research Fellow at the Center for Social Sciences, Institute for Legal Studies, Hungarian Academy of Sciences Center of Excellence, and he's also Associate Professor at Corvinus, University of Budapest. He was an intern at the appeal section of the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia in 2004. So he will benefit a lot from his practical experience, and has taught international law at various universities in Hungary and abroad, including the NATO Defense College in Rome. Professor Hoffman is presenting on freezing or consolidating International Criminal Court and customary international humanitarian law. Professor, the virtual floor is yours. Thank you.
Thank you very much. Can you all hear me? Yes, excellent. This is like a modern seance. I always have to see whether others can hear me or not, whether I'm still with you or not. Okay, so good afternoon, ladies and gentlemen. Thank you very much for being here. And first of all, I would like to congratulate the organizers, especially Andre and Martin, for this amazing conference. I feel really privileged to be included in this stellar lineup. And thank you, Martha, for the kind words as well. I mean, especially about the words of my practical experience, which are quite minuscule compared to some of the people in this same lineup, I would say. Without any further ado, I would like to turn to my topic. First of all, I would like to ask for your forgiveness if I'm sometimes a little bit distracted. I'm right in the middle of moving to a new apartment, so I try to arrange my camera in a way that you don't see big boxes full of clothes and everything like that, but hopefully this will work out fine. But first of all, I should find my presentation. And okay, I hope you can all see my presentation as well, the slides. Excellent, so let's get started. So as you've all heard, the title of my presentation is Freezing or Consolidating the International Criminal Court and Customary International Humanitarian Law. So first I should probably explain a little bit what I mean and why I chose this word freezing. Now, most of you are obviously experts on the ICC and the history of ICC, so this is probably not unusual for you. But back in 2002, Professor Alain Pelé had a quite harshly phrased chapter, to say the least, about the applicable law of the ICC statute in the commentary to the Rome Statute, edited by Professor Cassese, in which he did not mince words about what he thought about the arrangement of sources in the ICC statute. So as you can see, among others, he said that under the pretext that this exercise was rendered necessary by the criminal law principle of legality of crimes and misdemeanors, the negotiators have mechanically transposed an internal legal principle to the international sphere, by which they have frozen customary definitions in a process of rapid evolution. And this, according to Professor Pelé, was the result of a veritable brainwashing operation led by criminal lawyers with the self-interested support of the United States. Now, other commentators probably didn't go this far as Professor Alain Pelé, who is well known about not hiding his true colors behind kind words. But we have a lot of academic commentators who have similarly observed the decline or decay of custom as a source of international criminal law. So, for example, Professor van den Herik in a recent chapter tried to outline that. So it seems to be kind of like, I would say, an academic consensus that since the adoption of the Rome Statute, the development of custom, and especially customary international humanitarian law, has been significantly curtailed. So in my presentation, I would try to give an answer, first of all, to what extent this is actually true, whether this is inevitable, and if it is, on what the reasons behind it. So in order to discuss that, let's start with the basics. Let's start with the actual written law of the ICC statute. So we start at Article 21, which lists the applicable law. And as all of you know, this provision actually is very different from similar provisions in other international courts and tribunals. So compared to the ICJ, for example, here we see a clear hierarchy of sources. We see that there is a difference between the sources that are listed in the first place and in the second place and in last resort. So we see that the drafters of the statute indeed wanted to relegate custom to the second place. If it's possible, obviously, they might not have wanted it to be applied at all. Now, I will come back to it, whether this is actually possible, but the intentions are indeed quite clear. I mean, just to mention the obvious fact that the ICC statute does not even mention the word customary international law. Instead, it disguises it under very different rubrics. So I've highlighted the reference to custom, to actual custom here, which is, of course, the principles of rule and rules of international law, including the established principles of the international law of armed conflict. And of course, one might say that the reference to internationally recognized human rights is also a reference to customary international law, even though that's not really obvious from the statute. Now, of course, arguably, the reason behind this is the perceived inconsistency between the application of customary international law and the principle of legality, or nullum crimen sine lege. And this is again underlined by the fact that the ICC statute, unlike the ICTY or the ICTR statute, does specifically provides for the application of the principle of legality. So as you can see, this is the classical construction of strict legality, whereby the definition of a crime shall be strictly construed and shall not be extended by analogy. In case of ambiguity, the definition shall be interpreted in favor of the person being investigated, prosecuted, or convicted. Now, there seems to be a direct contradiction then between the application of customary law and the provision prohibiting a loose application or interpretation of crimes. However, and this is something we'll come back to during the lecture, this provision, in fact, doesn't apply to ascertaining the law, but it applies to interpreting the law. Now, there might be a difference, or there might not be a difference. I mean, this is an argument that is very much based on your own methodological preferences. Okay, so if we go on, we see that the ICC jurisprudence seems to affirm this stance. So the ICC judgments or decisions have very, very few explicit references to customary international law. So one of the few references was back in 2009, when in the al-Bashir arrest warrant decision, the court held that custom can only be applied when there is a lacuna in the written law contained in the statute, the elements of crimes and the rules. And such lacuna cannot be filled by the application of the criteria provided for Articles 31 and 32 of the Vienna Convention on the Law of Treaties and Article 21, subparagraph 3 of the statute. So basically here, the court declared that if we cannot find a proper solution based on the text and the interpretation of the text, then we might resort to custom as a last resort. However, this is not necessarily true, even though, as I said, the ICC actually refers to custom only exceptionally. So I've checked last night the Ongwen decision, which is the latest judgment of the International Criminal Court, and there is one single explicit reference to customary international law in that. And that's 1,000 pages long decision. So this seems to support this argument that, well, custom has no role in ICC jurisprudence at all. But of course, in the same judgment, we see repeated references to human rights treaties and instruments, even non-binding instruments, such as, for example, the Universal Declaration of Human Rights. So these references to human rights instruments cannot mean anything else than relying on custom, since these human rights instruments are not necessarily applicable to the actual case. And actually, the ICC regularly cites not just human rights instruments, but the jurisprudence of international human rights courts and tribunals as well. So there is a detectable current of actual application of custom. And this is, of course, not an accident. As we have seen, the statute actually provides for the opportunity to apply custom. We have already seen Article 21, which speaks about principles and rules of international law and refers to internationally recognized human rights. But there are specific criminal law provisions as well. So there are 2 war crimes provisions, both referring to non-international armed conflicts, where the court refers to applicable crimes within the established framework of international law. And again, reference to the established framework of international law is an obvious reference to customary international law. So even if the ICC statute tries to curtail the applicability of customary international law, it doesn't preclude it. And of course, again, it depends on your own methodological preferences, as I said, but arguably it would be impossible to preclude the application of custom anyway, even if there were no such explicit textual references to customary international law, since the mere application of the law or the application of an abstract norm to an actual situation necessarily involves making a decision between different possible outcomes. And as such, there is a need to decide, and if there is an outside source which gives us this decision, then it's inevitable that the judge will rely on it. But of course, there is a huge difference between relying on custom as an interpretative framework or an interpretative instrument during decisions and applying custom and introducing new crimes as such. So in order to understand why this hostility that we experience concerning the International Criminal Court's potential application of custom, establishing new crimes, is of course we have to go back in time. We have to start from the real beginning with the jurisprudence of the International Criminal Tribunal for the former Yugoslavia. Now, since I'm speaking in front of an expert audience, obviously I won't go into the nitty-gritty of how the ICTY was created and what different judgments it was responsible for, and so on and so on. But the ICTY itself prides itself of being an innovative force and actually creating international humanitarian law. So this quotation that you see on the slide is actually from the website, the official website of the ICTY. And among its achievements, it lists the following. It starts with saying that since its establishment, the tribunal has consistently and systematically developed international humanitarian law. And it concludes by saying that the legal precedents set by the tribunal have expanded the boundaries of international humanitarian law and international criminal law, both in terms of substance and procedure. So the ICTY clearly does not pride itself on just concretizing ambiguous questions of international law, but actually pushing the boundaries. And pushing the boundaries actually means creating new law. So this is a very, very interesting situation, since the ICTY obviously was created under the pretense of simply applying international humanitarian law and not creating it. And yet it became well known for this role. Now, this is something that we can already see with the very first decision of the ICTY, the first real decision, I mean. And that was, of course, the Tadic jurisdiction decision back in 1995, which is famous for creating completely new legal regulation, most importantly, at least for my field of research, for the law of non-international armed conflicts. So many authors have tried to somehow conceal this law creation by referring to innovation, by referring to novel jurisprudence and things like that. But this was actually completely new law, no questions about that. But what is very important, of course, that this revolution in lawmaking was disguised as conservative ascertainment of customary law. If you read Tadic, you will see that the court always tries to base its conclusions on state practice and opinio juris. Now, of course, this state practice and opinio juris is probably not extremely convincing. There are only a few references to specific states doing or saying something, but at least from the outside, it seems like a conservative approach to the ascertainment of customary international law. And this actually enabled many commentators to simply claim that, well, the ICTY is just applying law. It's a conservative institution. Most memorably, for example, Professor Murray stated that this is a conservative methodology. Now, this is not always true, of course. I mean, there is one very, very glaring exception from that, and that is the Kupreshkic trial judgment back in 2000, which has been quoted by, I would say, those international lawyers who would like to push the boundaries even further. Because in this case, of course, the trial judgment dispensed even with the appearance of conservatism. And it basically said that opinio juris, so basically moral principles, can create law. If something is bad enough, then it should be unlawful per se. Now, of course, this is probably one of the most spectacular failures of the Yugoslavia Tribunal as well. I mean, the Kupreshkic trial judgment, it's arguments about customary law as, in certain cases, a reflection of demands of humanity and dictates of public conscience, has not been retained in the established jurisprudence of the ICTY or in any other international criminal courts and tribunals. So this already gives us a hint of why the Yugoslavia Tribunal was so successful in international lawmaking in the supposed application of new customary law, but it also gives us a hint why the ICC would not be able to repeat this feat that the ICTY so successfully pulled off. So let's take a look at why the ICTY was so successful. And as you can see, I have listed basically 6 extremely important reasons for that. The first one is, I think, well, kind of obvious. I mean, the ICTY was simply created at the right time. It was created after the end of the Cold War. It was created at the time when the great powers had a relative agreement about such issues, even about the creation and application of international criminal law. So in many ways, this was a Nuremberg moment. This was a moment where the great powers agreed on creating a tribunal and agreed on creating a tribunal that potentially can create law. Now, of course, the great powers never admitted that they would give competence to the ICTY to do that. But of course, after the Nuremberg Tribunal, it must have been obvious to everybody that it is one of the potential outcomes. And of course, this is coupled with the second reason that I've listed, and that is the ICTY was, of course, a safe tribunal. I mean, the late Professor Cryer has created this distinction between safe and unsafe tribunal, and I think it's obvious that the ICTY was a safe tribunal. It was like a genie in the Aladdin animated movie, cosmic power in an itty-bitty space. So the ICTY had unbelievable power, but that was confined to the territory of the former Yugoslavia. So obviously, for the Big Five, it was really safe to acknowledge that within this very limited space, the ICTY would have a lot of power. Needless to say, that's completely different with the ICC, which is created by a treaty and which exists under, which has to operate under enormous political pressure. Now, the third reason that you can see is, of course, that at that time, international criminal law was really, really underdeveloped. I mean, we had this Grotian moment of creation of international criminal law in 1945 with the Nuremberg Tribunal and to a lesser extent with the Tokyo Tribunal. And then we had basically nothing. We had recess for 4 decades. And in order for the ICTY to operate, it was basically inevitable to try to create new law, since without that, I mean, they could not have solved probably most of their cases, or they would have had to resort to extremely contrived logic and argumentation. And of course, this was made easier by the fact that they had a moral high ground. They were, after all, judging cases where the perpetrators were accused of having committed international crimes, crimes against humanity, war crimes, and genocide. So under these situations, of course, the ICTY could face less scrutiny for, let's say, creating the customary law of non-international armed conflicts. After all, which state would have publicly protested against giving fundamental rights to civilians in a non-international armed conflict? Now, a fourth ground that I've found is that, of course, there was at that time a huge institutional competition with other international criminal courts and tribunals. I mean, that was arguably the heyday of international criminal justice, when one after another international criminal court and tribunal was created basically every year. And this has pushed the ICTY, but probably other international criminal courts as well, to push the envelope, push the boundaries as far as they can. And of course, today we don't really have that anymore. And the last two are reasons which are very, very seldom discussed, because I think the first 4 ones are kind of obvious. So I'm just reinventing the wheel here. But the fifth one, I think, is something that very few people actually discuss. And that is that the ICTY was very, very successful because it did not, in most cases, directly threaten the interests of great powers. They were delving in relatively safe subject matter. Now, I'm saying relatively because obviously genocide and crimes against humanity are not safe and are not war crimes. But if you think about that, especially from the angle of international humanitarian law, the ICTY was mainly focusing on non-international armed conflicts, so not on international armed conflicts, and this is a huge difference. And they very, very rarely touched upon operation law or battlefield law. So what they usually focused on was the mistreatment of protected persons. And this is a very important distinction, I think, because a jurisprudence which would have restricted actual battlefield law would have had a potentially huge impact on, probably my time is about to be up, right? Okay, just 2 more minutes, please, and I'm about to finish. It would have had a huge impact on the big powers as well. And if we think back of Kupreshkic, well, Kupreshkic was, at least that part that I was quoting, was about reprisals and the prohibition of reprisals under customary international law. And this has incurred the wrath of military law experts immediately. Because again, this is the sociological aspect of international law, but even within international humanitarian law, we have different tribes Of course, we have the academics, we have the military law experts and the ICRC people, they are together. And then basically we have human rights activists. And of course, military law professionals only allow ICRC people to mingle with them. And they would exclude everything else from that. So Kupreshkic was a great example for that, but I could mention Gotovina, where again, the whole military law expert field was at arms against the Gotovina trial judgment. And surprise, surprise, the appeals chamber completely changed that decision. And finally, and again, this is something that very few people talk about, is that the ICTY had a very distinguished person who was almost single-handedly responsible for changing custom. And that person was, of course, Antonio Cassese. Now, I've written a whole article about that. I'm not going into detail why I think that Cassese was almost single-handedly responsible for creating the customary law of non-international armed conflicts. But if you think about that, the most revolutionary judgments of the ICTY were all under his helm. And Judge Cassese left the tribunal in February 2000. His last case was the Kupreshkic trial judgment in January 2000. Now, again, maybe it's not that surprising that we don't have that kind of revolutionary approach at the ICTY anymore after that. And it's not surprising that we won't have the same thing at the ICC either, because the ICC operates under completely different circumstances. Basically, everything that I've listed with the ICTY is inapplicable to the ICC, including revolutionary personalities. I'm quite sure that states would not allow that any longer. So thank you very much for your attention, and I'm sorry for taking a bit longer time than I was allocated. And I'm looking forward to the questions, of course.
Thank you so much for that insightful presentation, Professor Hoffman. I find the concept of disguised custom fascinating and will be revisiting Article 21. Ragbi Vishnov, and I really hope that I pronounced your name correctly, will now present on comparing international criminal tribunals' interpretive approaches to IHL. I offer some highlights from Ms. Vishnov's CV. She is a PhD researcher at the European University Institute in Florence, where she studies cultural rights in international human rights law and international criminal law. Ragbi received the Oxford Merron IRMCT Internship Fund to pursue a fellowship at the Office of the Prosecutor of the United Nations International Residual Mechanism for Criminal Tribunals in The Hague. Alongside her PhD at the EUI, Ragbi is associated with the Public International Law and Policy Group as a research associate. The virtual floor is yours. Thank you.
Thank you, Dr. Bradley. Let me quickly share my screen. All right, are you able to see the screen? Great. And also able to hear me clearly. Okay. All right. Good afternoon and good morning, good evening to everyone who's tuned in from different parts of the world. Thank you very much, Dr. Bradley, for chairing this session. And thank you to my co-panelists. I realize that I'm in really illustrious company and I've already had received a lot to think about. So I must thank Dr. Hoffman for his presentation, which also speaks to themes that my paper looks to speak to. So it's quite helpful for me. Today, I'm going to present a work in progress. I'm going to caveat it at first already, where I analyze and compare the interpretive approaches that international criminal tribunals have applied in their readings of IHL. In my presentation today, I'll mainly be looking at the practice of ad hoc tribunals, but my paper also tries to look at the practice of the tribunal in Cambodia and the Sierra Leone tribunal. which for reasons of time, I will not be able to elaborately probe today. Now, the first question that my paper asks, and I realized that I should have gone into slideshow mode. Okay, so the first question that my paper asks is why a study of interpretation is even necessary? And for this, I give two very simplistic reasons. First, because it helps us identify IHL norms, and second, because it helps us apply these IHL norms consistently. Let me explain what I mean by these two reasons. Now, as Sandorsky remarks, IHL is largely self-executing by nature, but because of its self-executing character, it has also developed rather haphazardly, allowing states to use deliberate ambiguity to make room for discretion in the implementation of IHL norms. And therefore, when international criminal tribunals, like the ad hoc tribunals, which are tasked with prosecuting serious violations of IHL, when such tribunals are confronted with questions of IHL, they have no choice but to bring in interpretive approaches to make their way through the definitional void that exists in IHL. And this problem is made more pronounced in the context of customary law, as Mr. Hoffman just explained. Given that customary law is by design as well more fluid and dynamic, there is no choice but to resort to interpretive approaches to make sense of where to locate customary law. And here I assume that this is based on the assumption that there is, of course, some sort of coincidence and overlap between the international criminal law norm that is codified in the statutes and IHL. But as Shivakumaran usefully reminds us, that's not always the case. Illustratively, if we look at Additional Protocol 2, it speaks of a prohibition on conscription and conscription of child soldiers and their participation in hostilities. But in comparison with the Rome Statute only criminalizes active participation in hostilities. And therefore, when the ICC, for instance, is tasked with a war crime falling under A2E7 of the Rome Statute, it needs to find a starting IHL point. And that's where interpretation finds its way in. Now, the second reason I gave was that interpretation helps apply IHL. And here I recall one of the many foundational intellectual debates between British academics Lautepa and Schwarzenberger. While they differed on many questions of life and law, what they did agree on was the significance of interpretation and a study of interpretation. For Lautepa, study of interpretation is reflective of the method and spirit that a judicial tribunal will use in similar cases in the future, while for Schwarzenberger, interpretation is directly related. It's correlated to the quantity of weight that is to be associated with a decision and a judicial body as a whole as well. In other words, the higher the quality of interpretive reasoning, the more persuasive weight that decision carries. Now, given that there are valid reasons to study interpretation, let me quickly offer a summary of what I have found in the interpretive practices of the ICTY and ICTR. I must add here very preliminarily that the practice leans towards the ICTY, of course, because the ICTR was more occupied with questions of genocide, for example. And here we see lots of interpretive approaches picked up from domestic practice, recurring in the practice of the ICTY and ICTR. Starting with the literal approach, where, of course, tribunals accord plain and ordinary meaning to the norm. We see this in the Bagasora case, but also in Tardich and Alexovsky, where many scholars like Shebas have spoken about how literal interpretation veers towards strict construction. But if you probe practice more deeply, you see that literal interpretation has also been used for otherwise broad readings. For example, in Alexovsky, we see that literal interpretation was used to understand what inhuman treatment means, and that became a portal to bring in principles of humanity within the definition of inhuman treatment. And the ICTY in Delalich also went so far as to identify some subcomponents of literal interpretation, all of which again are borrowed from domestic practice, such as ejusdem generis and the expressio unius rule. We don't see these rules being applied that commonly, more often for questions of procedure than for questions of substantive IHL. The second approach that is also recurrent is the logical approach, where the court tries to prevent absurdity in the IHL norm. And I found that the logical approach is often couched sometimes in devices like causation. For instance, if we look at the Delalich case, the ICTY notes there that a superior cannot be held criminally responsible for a failure to prevent a crime committed by the subordinate, saying that it is logically inappropriate because there could be no causal connection between the two. And we see that the logical approach is not expressly articulated, but there is an interest in preventing absurdity, which is couched in different sorts of tools. Third, we have the contextual approach, where the tribunals look to historical antecedents and circumstances of the time to give meaning to an IHL norm. Most famously, this was done in the Blaskic case, as well as in Tadic, where the tribunal looked at the Hague regulations, as well as statements of the Secretary General of the UN to delineate the scope of Article 3 of the ICTY statute. Next, we have the effectiveness approach, where the objective really is to prevent futility of the IHL norm. And I noticed that the way that effectiveness is used, there are two ways in which the ICTY has tended to use effectiveness. One, to improve the performance of the norm itself. And here, Kupreskic is a useful example, where the ICTY used a refrain of effectiveness to modify the weight that is to be assigned to state practice and opinio juris in IHL norms, noting that IHL is mainly consists of a lack of practice of prohibitive norms, and therefore the rubric has to be customized to improve the effectiveness of IHL. But otherwise, effectiveness is most often used to just prevent a vacuum of no law, to prevent a situation of lawlessness. And you see this most evidently in the overall control test that the Tadic case adopted, where it reduced the previously rigorous standard of internationalization to allow IHL norms to come into operation early on into the conflict. The last approach, the two other approaches that I'd like to speak about are the progressive interpretation approach, which, as Mr. Hoffman also explained, is largely in keeping with the identity that the ad hoc tribunals were trying to create for themselves, where the law was interpreted as a mirror to keep up with changing times. And you see this, of course, in Galich, as well as the Tadic jurisdiction case, but also quite acutely in the sexual war crimes cases at the ICTY, such as Kunarak and Akayesu at the ICTR, where sexual violence was decoupled from its previously mechanical anatomical understanding to move towards a more consent-based understanding, which allows for a wide range of crimes, but also a wider range of victims to be brought within the ambit of the crime. And finally, and most controversially, I think, is the teleological interpretation, or the purposive approach. Conventionally, purposive approach is used as an alternative to the literal approach. So when the literal approach fails, where a text is not clear, like it was supposedly in Tadic, where other violations of IHL was not clear, courts tend to take recourse to the object and purpose of the statute. But in the court's later practice, you see that object and purpose also becomes a rule of first instance, and a rule probably commanding equal, if not more weight than other interpretive rules. What is most remarkable about the way in which teleological interpretation is used actually is that the tribunals tend to not look at the object and purpose of their constitutive statutes, so the ICTR and ICTY statute, but look at the object and purpose of the underlying IHL convention, which, for instance, in the Furangia case, was identified as safeguarding the fundamental dignity of the human being. Now, in my analysis of the problems with these approaches, I try and use the scheme that Summers and McCormick developed. Lena Grover actually in her paper tries to simplify this and identifies three main steps in an interpretive process. She says you first start with a primary interpretive principle that you identify. Second, you offer arguments to support the invocation of this interpretive principle. And third, you rely on a catalog of interpretive aids to corroborate the arguments you offered. And we see here that the practice of the ad hoc tribunals fails on all three counts. Now, in respect of identifying the interpretive approach that is being applied, we see this most clearly when the effectiveness refrain is invoked in the court's decisions. So like I said, we have the Alexovsky case, which contains a refrain of futility, but the court does not expressly call it the effectiveness approach when it interprets the norms that were brought in question. Secondly, when the court does invoke a rule expressly, it does not offer sufficient reasoning for why that rule must be invoked, or why the way that it is being interpreted is most faithful to that rule. And we see this in two instances. In Blaskic, for example, the literal rule was actually used twice in the same decision. Once to strictly read the term instigation, and second to broadly read the term information. But the decision is wanting of an explanation for why either or both of these interpretations are faithful to the literal rule itself. Similarly, like I said, we also see this with the teleological approach, where the court bypasses the first check, which is that of the object and purpose of its constitutive charter, and looks at the object and purpose of the underlying IHL convention, or sometimes the IHRL convention, without sufficiently explaining why that bypassing is okay. And it is only left for readers and people interested in the law to surmise that this is because international criminal law was born out of a tripartite marriage, as some people say, between domestic criminal law, IHL and IHRL. But outside of the schema that Summers and McCormick offer, we also see that many times the interpretive approaches tend to overstep their limits. In other words, the interpretation of legal rules is often conflated to a direct interpretation of facts. And we see this most clearly in the identification of the laws applicable to a conflict, which are often conflated with the nature of the conflict itself. Now, there are two problems with this. First is, of course, this is not reflective of the reality on the ground. As we see, as the Galich Tribunal quite sensibly explained, that while there was the 22nd May Agreement, which allowed certain provisions of Additional Protocol 1 to be applied to the conflict, that doesn't necessarily convert the Bosnian conflict into an international armed conflict per se. But more importantly, it can have dangerous domino effects, as we see in the American decision, Hamdan versus Rumsfeld, where Common Article 3 was applied to international armed conflicts as a treaty, as the treaty itself, although the treaty contains a strict caveat against such application. And like Mr. Hoffman explained, a lot of this has got to do with the policy and political climate in which these ad hoc tribunals were situated. You see that they did not need to seek state support, and they also had complete autonomy over the burden of justification, over the rules and procedures that were applicable to them. And therefore, they were not so bound to sufficiently justify why they chose a particular interpretive approach. And it was all passed off or disguised as an interest in developing a rich legacy for future courts to bank on. But with the ICC model, we see that this changes. And the main advance here is Article 21 and 22 of the statute, through which the court is disallowed from criminalizing by analogy. It is also bound to resolve ambiguities in favor of the accused, so exhibit more traditional criminal court functions, so to speak. And here too, when we compare the interpretive practice of the ICC in respect of IHL with ad hoc tribunals, some trends seem to emerge. First, we see that the literal interpretive rule, so the literal rule is used more often, often even in a strict construction sort of nature. Again, which is emblematic of the fact that the ICC assumes more criminal court functions. So it's concerned about fair trial rights, principles like in dubio re and favor re. But nonetheless, we do see that the court tends to rely on object and purpose sometimes, especially in cases where the normative force attached to the prosecution case is very high. For instance, like in cases of sexual violence. And we see this in the Netanya case, where the court found that sexual war crimes could be committed against members of one's own armed forces, falling back on the trope of humanization, which is part of the object and purpose of the underlying IHL norm there. And like Mr. Hoffman said, there's lesser reliance on customary law, again, because of the caveats that are built into the design of the ICC. But what I found most remarkable was the way in which the effectiveness approach is now used at the ICC. Much like the ad hoc tribunals, effectiveness is still used to fill voids in the law, so to prevent a period of a legal vacuum. You see this in the way that the overall control test is accepted by the ICC without much challenge. Similarly, in Katanga, we see how the court treats the duality between international and internal armed conflicts by treating the rules of internal armed conflicts as a residual regime, as a default regime that comes into operation as soon as international armed conflict rules are not applicable. But more importantly, because of the fact that the court is set in a different political climate, we see that effectiveness is actually used to pursue ends of harmonization and preventing divergence between the different domains of international law that come into play. For example, we see this in Lubanga, where the court not only found that the conscription of child soldiers in fighting roles and child soldiers discharging fighting roles in hostilities was a war crime, but also child soldiers in supporting roles, thereby bringing the law in harmony with the other fields of international law that it speaks to. And you also see here a concern on behalf of the court to create a solid legacy, to ensure that its markers for performance in terms of ending impunity and achieving deterrence are effectively achieved. And this is why the court refrains from coming up with what some people say are ill-informed ICL positions, which may be too removed from what military commanders on the ground understand and rely on in their trainings. All right. And then finally, I'd just like to quickly address how this affects domestic interpretive practices. I think Herman Vanderbilt had a paper where he spoke about the 4 types of behaviors that domestic courts exhibit when they interpret IHL vis-a-vis the decisions that international criminal tribunals already have made. We see that oftentimes domestic courts demonstrate full compliance because of the normative and epistemic superiority they attach to decisions of international criminal tribunals. But on a larger consideration, you do see that domestic courts make greater room for state discretion and are generally more cognizant of the different considerations that come into play in judicial adjudication of IHL norms and real-time IHL norms in the way that they play out during the conduct of hostilities. And this leads me to, I think, what are the final takeaways and challenges that interpretive approaches still grapple with. First, as Shivakumaran very rightly invites our attention to, ICL is ultimately still an ex post facto regime, a backward-looking regime. And in the way that the International Criminal Court interprets IHL, you do see some consideration in its logical constructions, in its effectiveness constructions of the fact that there are a different set of parameters applicable to both regimes. We do not see it fully reflected in the court's understanding of certain principles like proportionality. And as Mr. Hoffman said, given that now the ICC is also tasked with a greater bulk of cases pertaining to Hague Law, pertaining to the conduct of hostilities, greater sensitivity and cognizance of these different parameters is quite relevant and important to the interpretive approaches used. Second, we have the classic clash between the presumption of protection and the presumption of innocence, where the court, owing to the greater normative force it attaches to the prosecution cases, it often errs towards applying rules that favor the victim, towards interpreting rules in a victim-friendly manner. And the collateral damage on account of this is the prejudice caused to the fair trial rights of the defendant. Conversely, even when it treats internal armed conflict rules as a default regime, that comes at the cost of fair notice and fair trial rights of the defendant. And I think a useful way out of this would be, instead of to apply the laws applicable to the conflict as a whole, to check whether in each crime the IAC versus NIAC classification amongst them, which of them favors the accused. And while I understand that this may come at the cost of some acquittals, it is still more aligned with the court's objectives as a criminal court. And finally, I think interpretive approaches must also take account of the fact that they are steeped in politics. They come from political origins and they also are in direct conversation with politics. And while the ICC and criminal courts in the past have tried to preserve a strict separation between the legal and the political, I think continuing to utilize this strict separation will only present a more distorted picture of ICL and its interaction with IHL, not only for the legacy of the court itself, but also for the stakeholders whose compliance the court so dearly cherishes. With that, my presentation comes to an end. Thank you so much for listening, and I really look forward to questions and feedback.
Thank you so much, Robbie, for absolutely perfect timekeeping. I'm so impressed with that. What a fascinating presentation. I'm sure that we can expect an interesting discussion later on the topic of interpretive approaches. I personally also look forward to reading your PhD. Next, Demetra Lazalle, and I hope I pronounced that correctly with my thick Afrikaans accent, will present on the development of IHL in jurisprudence of the ICC, formulation and interpretation of Article 8 of the Rome Statute. Some highlights from Dr. Lazalle's very impressive CV. Demetra is a lecturer in international criminal law and skills at the University of Central Lancashire, Cyprus. Her main areas of expertise are international criminal law, international humanitarian law, and human rights law. Demetra's research interests also include legal reasoning and approaches to interpretation. Since 2016, she is a contributor to the online database Oxford International Organizations, published by OUP. We look forward to your presentation. Thank you.
Thank you very much. Can you hear me? Okay, let me share the screen first. Can you see my screen?
Yes.
Thank you so much. First of all, let me say a couple of words. I'll promise I'll try to keep my presentation within the 20 minutes limit. I would like to thank you for the honor for being here today, albeit in a virtual form. We will all meet in person. Hopefully we will do so pretty soon. My presentation will build upon what my fellow panelists have already said. So for the sake of simplicity, I will try to avoid overlaps and provide my own contribution on the topic. Now, as Dr. Bradley has said, my presentation title is The Development of International Humanitarian Law in the Jurisprudence of the ICC. And my focus will be firstly the formulation of Article 8 as adopted back in 1998, and then in the second place, the interpretative approaches followed by the ICC chambers within the remit, within the limitations provided for in their own statute itself. Now, the exploration of these two issues will illustrate some distinctive characteristics of the ICC's contribution to the development of IHL and how it may be distinguished from the earlier works of other international courts and tribunals such as the ICTY and the ICTI. So let's get started with the relationship between ICL and IHL before the establishment of the ICC itself. Now, as my fellow panelists have said, and earlier on this morning, despite their formal status as subsidiary means for the determination of rules of law, judicial decisions of international criminal courts and tribunals have long played a key role in the identification and clarification of international criminal rules and in the advancement of IHL. And notably in its first major ruling in the Tadic case, the ICTY interpreted the scope of its jurisdiction with reference to IHL to determine what? That it had the power to prosecute all serious violations of international humanitarian law. Now, prior to the ICC, I mean, I won't go into and new detail as to the ICCTY's and the other tribunals' interpretative approach. This has already been covered with precision and detail beforehand. But what I would like to say is that prior to the ICC, the tribunals were faced with different challenges with scant war crimes definition, which did not sufficiently define the constituent elements of the crimes. And significantly, gaps were filled by means of judicial interpretation, whereby the courts clarify the scope and content of war crimes by relying heavily on the relevant IHL rules. Hence, the development of IHL by this court was inextricably linked with the wider IHL framework, which, as already stated, often extended beyond the strict parameters of the war crimes provisions themselves. Now, in this respect, the statutes of the ad hoc tribunals were arguably jurisdictional in nature. I mean, adherence to the principle of legality was assessed with reference to customary international law, especially as regards the ICTY. The situation has been reversed in the case of the ICC. In the case of the Rome Statute, as we have already seen, there is not really much need to test the definitions of the crimes against the backdrop of customary international law in order to determine whether they comply, for example, with the principle of legality. Under the Rome Statute, the starting point and the main focus of any interpretative exercise is the crimes definition itself in Article 8 of the Rome Statute. Now, what happened back in 1998? Now, essentially, an exploration of the ICC's role to the development of IHL invites the question as to the extent to which the ICC itself can be seen as a norm interpreter, articulating and reinforcing norms of international criminal law under the Rome Statute, and more broadly under IHL and general international law. The dynamics of this relationship has been redefined because of the extensive treaty proper negotiations which took place during the adoption of the statute, the participants involved, and then the result of this process. Significantly, it was the first time that war crimes were negotiated as part of a multilateral treaty for the purpose of setting up an international judicial institution to deal with individual criminal responsibility. And during the drafting, there was general consensus that the crimes definitions would reflect existing customary international law and not create new law. I mean, that's quite obvious and for granted. Now, in view of the above premise, the question raised, and was also raised previously by Dr. Hoffman, is to what extent the outcome of this process represents something more than mere codification. The process by which the crimes definitions were negotiated and renegotiated has had an extensive effect on their final form, though, and their normative potential as a result. Hence, while the drafters proceeded on the premise that they were dealing with existing crimes rather than new crimes, the highly legalized formulation of the crimes in the end necessarily incorporates an element of progressive development. The Rome Statute is a significant leap forward, both in terms of the elaborate definitions of the crimes, and not only war crimes. I mean, crimes against humanity are the other obvious example, but also Rome Statute places an unprecedented focus on the principle of legality compared to previous tribunals. The pertinent question here is the extent to which the strict legalism which characterizes the definitions of the crimes may hinder the development of the ICC crimes. Moreover, as already stated, the court was established at a much more advanced stage in the development of international criminal law norms. At the same time, we must not forget some particular characteristics of the ICC. The ICC is the first permanent penal institution of its kind, which is going to be involved simultaneously in a number of situations which exhibit different characteristics. This aspect is expected to have an impact on the gradual, on the long-run development of the crimes by means of judicial interpretation, whereby the ICC provides an authoritative reference point on the scope of the crimes within its jurisdiction. Now, although the Rome Statute is a highly legalized instrument, still its nature is dominated by substantive justice considerations. We must not forget this. As a result, the statute's legalism is in tension with the treaty's object and purpose, which, at least from a substantive justice perspective, calls for a teleological interpretation of the crimes. A teleological interpretation of the crimes is further supported by the argument that the Rome Statute could be qualified as a lawmaking treaty. That is, a treaty whose influence can extend beyond its contractual boundaries and effect changes under customary international law, including the crimes within the jurisdiction of the court. Now, the ICC interpretative approach, and that's its ability to develop the crimes within its jurisdiction, is circumscribed by a number of factors, which I will set out in turn. In the first place, it is necessary to consider the principle of legality. Most importantly, the ICC is the first international tribunal to explicitly contain provisions relating to the different components of the principle of legality, which are found in Articles 22, 23, and 24, respectively, of the Rome Statute. And as discussed shortly, the ICC chambers are cognizant, they are very much aware of the inherent tension between the treaty's object and purpose and the principle of legality. Now, moving on to the formulation of war crimes in Article 8. Now, aside from the crime of genocide, the drafting of crimes against humanity and war crimes on many occasions involve the substantial alteration of existing rules. This is especially obvious in relation to war crimes. The bulk of acts in Article 8 were based on widely ratified conventions, yes, but and many of which they were already considered to be part of customary international law. But the added detail in relation to a number of crimes included in Article 8 was to remedy the rather scant and vague wording of some of these primary rules of IHL. And this entailed the effective transition of war crimes from rules of IHL, sometimes ill-fitted for the purpose of individual criminal responsibility, to a fully fledged and modern war crime definition. Now, on the other hand, we must be aware that Article 8 has indeed been criticized as being a retrenchment in international law. Unlike the ad hoc tribunals, Article 8 is a closed list of crimes. Also, it has the very important defect of expressly excluding some serious threats to international peace and security. I will come back before I discuss the ICC's case law on Article 8's inextricable link with IHL. But beforehand, I would like to discuss the elements of crimes and Article 10 of the Rome Statute. Now, according to Article 9 in the first place, the elements of crimes are there to assist the court in the interpretation of the crimes within its jurisdiction. Now, despite their non-binding status, the elements of crimes have created a consistent framework with consistent and modern terminology. And as the pretrial chamber said early on in the Al-Bashir case, it will not deviate from them unless there is an irreconcilable contradiction between the Rome Statute and the elements of crimes. And moving on to Article 10. Now, Article 10 of the Rome Statute deserves attention because it attempts to define the relationship between ICC crimes and rules of international law. The provision states that nothing shall be interpreted as limiting or prejudicing in any way existing or developing rules of international law for purposes other than this statute. Now, notably, this provision was originally proposed in the context of negotiations on war crimes. Now, the International Committee of the Red Cross was particularly concerned that omissions from Article 8 should not be taken as evidence that they do not constitute war crimes. Now, despite its intended purpose, Article 8 arguably constitutes an acknowledgement on the part of the drafters as to the ICC's lawmaking potential. Moving on to something which was already been touched upon, the very important provision, Article 21, and the applicable law before the chambers. Now, as shown by the court's application and interpretation of the crimes to date, the starting point is unequivocally the definition of the crimes. Now, this is confirmed by Article 21 of the statute, which sets out the applicable law. And according to the provision, the chamber shall in the first place apply the statute, the elements of crimes, and the rules of procedure and evidence. References to international law or general principles of law in paragraphs B and C have been characterized by the ICC chambers, for example, in the Bemba trial chamber judgment, as subsidiary sources of law, which may only be relied upon when there is a lacuna in the statute, the rules of procedure and evidence, and the elements of crime. So the question is, what methodological interpretation is invited by Article 21, and how does it relate to the ability of the ICC to contribute to the development of IHL? Now, the court has established that the interpretation of the statute is governed by the Vienna Convention on the Law of Treaties. The general rule of interpretation in Article 31 of the Vienna Convention prescribes that the various ingredients, these being the ordinary meanings, the context, the object and purpose, are to be considered together in good faith. The court has discussed the extent to which the principle of legality can be reconciled with the general rule of interpretation. According to the court, the interpretative method invited by the general rule must always be consistent with the principle of legality, which constitutes, and I'm quoting, a clear and explicit restriction on all interpretative activity. The court in the Katanga case referred to the tension between the principle of legality and the general rule of interpretation in the context of international criminal law, in particular where the object and purpose of the treaty appear critical for the interpretation of the statutory provisions. And in this regard, the court stated that recourse to a teleological approach could be considered antithetical to the principle of legality. According to the chamber, it is self-evident that the aim of the statute to put an end to impunity for the perpetrators of the most serious crimes within the jurisdiction of the court can under no circumstance be used to create a body of law extraneous to the terms of the treaty or incompatible with a purely literal reading of its text. Nonetheless, the object and purpose, so the court came back to the object and purpose, the object and purpose of the statute must always be borne in mind and fully considered during the interpretation of its provisions, as they are one of the components which make it possible to establish its definite meaning. Now, let me highlight in brief terms the link between Article 8 and IHL. Now, Article 828 is quite straightforward. It criminalizes violations of the grave. It criminalizes grave breaches of the Geneva Conventions. Article 8.2b refers to serious violations of the laws and customs of war in international armed conflict. Now, its provisions are drawn both from customary law, mainly the Hague regulations, and widely accepted treaty law, such as Additional Protocol 1. Article 8.2c deals with serious violations in non-international armed conflicts. Notably, the proscribed acts in Article 8.2c, rather than being based on Additional Protocol 2, they have been included to the extent that they have formed part of Article 8.2b. This is an interesting comment on the side. Now, before proceeding, in terms of the relationship of Article 8 with IHL, now it is necessary to continue to the case law. And for lack of time, this will be a perusal of the court's case law to identify instances which demonstrate how the Chamber's interpretation of Article 8 can influence the development of war crimes and perhaps IHL more broadly. But these are by no means exhaustive, and a number of them have already been discussed earlier on. Now, I will turn to the obvious aspect, being child soldiers in the first place. Today, the ICC has considered in a number of cases the war crime of conscripting, enlisting, and using child soldiers under the age of 15 to participate actively in hostility. Now, the court's case law on this crime and other crimes against children, namely sexual violence and rape against child soldiers, as discussed beforehand, illustrate the court's willingness to push the traditional boundaries of international humanitarian law in this area. Now, the use of child soldiers in hostilities was considered by Lubanga, the first case to come before the ICC. And our discussion here will be brief and will focus on the court's interpretation of active participation in hostilities. Now, while IHL treats active and direct participation as synonymous and being used interchangeably, the ICC's interpretation of active participation reflects a broader understanding of the term compared to its meaning and scope under IHL. Now, quoting from the appeal chamber decision in the Lubanga case, the appeals chamber said, the interpretation given to Common Article 3 of the Geneva Conventions in the context of the principle of distinction cannot be simply transposed to that of using children in hostilities under Article 8 of the Rome Statute. Rather, the term participate actively in hostilities must be given an interpretation that bears in mind that provision's purpose. Now, in this regard, in Lubanga, the ICC chambers concluded that the term active can encompass both direct and indirect participation in hostility. And the question which arises is how the court's interpretation fits within the broader IHL framework and principles, such as the principle of distinction, and the extent to which it may bring about normative changes under both international criminal law and international humanitarian law. For example, is this interpretation particular to this very peculiar war crime? At first sight, there is indeed an inconsistency between the meaning and scope of direct participation in hostilities for the purpose of keeping children out of hostilities with the meaning and scope of the term for the purpose of distinguishing between competence and non-competence. The underlying premise of the ICC's reasoning is to be welcome. It seeks to provide children with the widest scope of protection in terms of punishing those who are responsible for their recruitment. At the same time, this approach must be reconciled and located within the broader IHL framework in order to understand how it may promote the development of IHL. Otherwise, civilians, including children, are more likely to become legitimate targets on the basis of a broader understanding of active participation in hostilities. The court's interpretive approach was followed in later cases which dealt with the same war crime. Now, significantly in the Uganda case, the ICC took a step further and convicted Uganda for the commission of rape and sexual slavery against child soldiers by members of their own group. Now, during the proceedings, the defense persistently and quite convincingly argued that the court could not exercise jurisdiction over these crimes because IHL does not protect competence in hostilities from crimes committed by members of their own group. There is merit in the court's approach in that it seeks to address an obvious weakness in terms of protecting children during armed conflict. Sadly, sexual violence is an all too common feature of warfare, and it does fly in the face of logic to argue that such contact is not associated with hostilities. However, from an IHL perspective, active competence, including children, are not protected from violence committed by members of their own group. Now, according to the trial chamber in the Uganda case, members of the same armed force are not per se excluded as victims of war crimes of rape and slavery under the Rome Statute, under IHL, and under international law more generally. It was what was referred to in the morning, the lack of status requirements. Now, the appeals chamber conclusively rejected the defense challenge by saying that in the absence of any general rule, excluding members of armed forces from protection against violations by members of the same armed group, there is no ground for assuming the existence of such a rule specifically for those two crimes. How much time do I have, or have I overstepped my time?
You will have 2 minutes to conclude, please.
I'm almost done, okay.
Perfect.
Thank you, my apologies. Lastly, with respect to the Uganda case, the chambers were cognizant of the fact that their interpretation was of an unprecedented nature, and they referred to the defense's argument that this was a wide application of their own statute, which was pursued by way of judicial activists. But the appeal chamber said that the armed conflict nexus is the appropriate criterion for delimiting the war crimes from ordinary crimes. Oh, my apologies. And last but not least, I wanted to highlight very briefly the court's latest decision in the Ogwen case, where for the first time, the war crime of enforced pregnancy someone was convicted for this crime, and the court's interpretation of the elements of the crime are expected to be an important input in the works in the court's evolving case law. Now, concluding, now the court's work in prima facie internal conflicts, this has already been highlighted beforehand, has meant that Article 8 jurisprudential advancement has unevenly shifted in favor of war crimes committed in international conflicts. And moreover, the court's case law has demonstrated the multifaceted lawmaking potential of the ICC. It revealed how the ICC can potentially accelerate the development of specific crimes. And this also is relevant when it comes to a case selection and charges selection on the part of the prosecution. Lastly, I mean, the ICC's non-situation specific ambit is a unique factor which forms parts of the ICC. And the court will be involved in numerous situations, in numerous diverse situations. And this will mean that different considerations will come into play when interpreting the crimes. And this will also ensure the continuity of its jurisprudence. And concluding, the ICC establishment seems to have redefined the relationship between treaty law, in our case, Rome Statute, and general international law, at least as regards the crimes within its jurisdiction. And in this respect, the Rome Statute provides the backdrop for effective normative changes. My apologies for the delay.
Thank you so much, Dimitra, for that fascinating presentation. Indeed, the interpretation, formulation, and application of Article 8 remains so crucial, especially also on my own continent, the African continent, when there's various ongoing NIACs. So thank you for this very valuable contribution. Our final panelist is Sergei Masol, who will present on human rights rules and principles in the legal regime of the International Criminal Court, fine-tuning the superlegality approach. Just a brief highlights from his CV as well. Sergei is a Doctor of Laws, European University Institute in Italy. During the doctoral program, he worked as a research assistant at the European University Institute and was a visiting researcher at the University of Copenhagen, Denmark. He was also an assistant editor at the European Journal of International Law, as well as a senior editor and the head of the International Law section at the European Journal of Legal Studies. Sergei, we look forward to your presentation. The virtual floor is indeed yours. I think, Dimitra, if you could just unshare your presentation. Thank you so much.
Good afternoon. Thank you, Dr. Bradley. Yes, I'm waiting for Dr. Loizou to stop sharing her screen, and then I will share mine.
Give me just a second.
Just close it.
See a red button.
Close it.
That says leave,
okay.
Stop share screen.
Oh, that was so obvious. My apologies.
So. Do you see my PowerPoint?
Yes, and we can hear you. Thank you.
Great. So slideshow. Yeah, everything is fine with my PowerPoint, right? Great. So good afternoon again to everybody. I will be speaking about a section of my PhD thesis, or to be precise, a paper which is loosely based on my PhD thesis, which I defended last year. And the title of my presentation is Human Rights Rules and Principles in the Legal Regime of the International Criminal Court, Fine-Tuning the Superlegality Approach. First, I will start with the theoretical framework, and I will rely on Robert Alexie's theory of constitutional rights, and more particularly the distinction between rules and principles. This theoretical framework will be of utmost importance for my arguments regarding the superlegality approach. So after this theoretical introduction, I will proceed with the discussion of the superlegality approach itself. I will provide an overview of Article 21(3) of the Rome Statute. I will outline 5 arguments from the academic literature against this approach and my 5 counter-arguments defending this approach. However, I will also fine-tune this superlegality approach to make it look less omnipotent as it might be at first sight. And finally, I will address the applicability of this approach to both procedural and substantive legal norms, because I assume that for many people, its applicability to the latter would be questionable. To begin with, the theory of constitutional rights, or Theorie der Grundrechte in the original language by Robert Alexie, is a very complex theory. I will not discuss it in full, of course. What is the most relevant for me and for my presentation is his distinction between rules and principles. So for Alexie, every norm is either a rule or a principle. So the former shall be applied in an all or nothing fashion after the determination of the scope of its application, whereas the latter shall be applied in a more or less fashion. Principles are optimization requirements, and the weight of reasons behind them differs from case to case, depending on what is to the greatest extent factually and legally possible in the light of any opposing principles and rules. This explains the gist of their interpretation. To interpret principles means to assess their weight in regard to others, while to interpret rules means to assess, means to determine the ambit of their application. Thus, any collision between competing principles is resolved by the act of balancing. Any seeming collision between rules and principles is simply non-existent, and a more careful examination of their content is needed. And finally, any collision between rules is resolved by either regarding one of them as an exception to another or declaring one of them invalid, in particular by means of the legal maxim lex specialis derogat lege generali. Importantly, the theory in question is not confined to constitutional law. Quite the contrary, it is equally applicable to international criminal law norms and human rights law norms. As you can see from the German original version, it's not called Theory of Constitutional Rights, as the English translation of Alexie's monograph suggests, but it's actually Grundrechte. It's something bigger than constitutional rights. So having provided this introduction, the theoretical introduction, I will proceed with anatomizing Article 21(3) of the Rome Statute. Some other parts of this article, Article 21, have already been discussed thoroughly during this conference, and I will focus only on this little paragraph, but which is of fundamental, if not constitutional importance for the ICC. And it says, and I quote, you can see it on the screen, the application and interpretation of law must be consistent with internationally recognized human rights. There have been essentially 2 understandings of this provision in academic literature and practice. And these are first the so-called truncated approach. Please don't pay much attention to the wording. It can easily be called the narrow approach or the interpretive approach. It essentially means that applicable law, and which is hierarchically listed in Article 21(1) of the Rome Statute, shall be interpreted in light of human rights law. This understanding of Article 21(3) has hardly ever been doubted. At the same time, there is another approach, another understanding of this provision, and it's called the superlegality approach, the term coined, if I'm not mistaken, by Professor Pellet, the French scholar and practitioner, and supported in academic literature later on by some scholars, not all of them, though. And according to this approach, international human rights law as a material source of law, and notwithstanding the formal source of its origin, can set aside any applicable law in the hierarchical order under Article 21.1 of the Rome Statute. The ICC has applied both approaches in different cases without any consistent logic, and sometimes make it difficult for a reader to understand which weight is given to any of these approaches by the judges themselves. One, perhaps the best example of this bewilderment is the well-known asylum saga in the Katanga and Ngujolo case, where in 2011, trial chamber delayed the return of 3 witnesses to the Democratic Republic of the Congo, enabling them to exercise their right to apply for asylum in the Netherlands and to exercise the right to an effective remedy. And basically, the chamber stated that it is unable to apply Article 93.7 of the Rome Statute dealing with these issues of transfer in conditions which are inconsistent with internationally recognized human rights as required by Article 21.1. In other words, it adopted the superlegality approach, according to which any applicable law may be declared inapplicable in a certain case. Importantly, the human rights consistency test does not make the applicable law, in this case, Article 93.7, void. Such a consequence stems only from a violation of a jus cogens norm. This notwithstanding, 2 years later, in 2013, the trial chamber turned its previous understanding upside down and complicated the matter even further. It essentially stated that the principle of non-refoulement is a jus cogens norm. And the only means to adhere to this norm is to suspend Article 93.7 of the Rome Statute temporarily and not apply it should the asylum claims of the detainees, of the detained witnesses succeed. I will not delve deeply into the discussion whether non-refoulement is indeed a jus cogens norm or not. It's a separate issue, but let's assume that some human rights are jus cogens norms. The problem is that there is no need to refer to Article 21.3 in this respect, because then the invocation of a jus cogens norm will lead to making other conflicting norms void. So there was no need to refer to this provision, but essentially the ICC tacitly approved the superlegality approach even in this 2013 decision. So you see that the ICC doesn't really try to explain their rationale behind using internationally recognized human rights for interpretative purposes or for the purposes of application. In academic literature, there have been many debates about internationally recognized human rights and whether the superlegality approach can be defended or not. And I have summarized 5 main arguments against the superlegality approach, and you can see them on the screen in rectangular form. I will go one by one and try to refute all these arguments defending the superlegality and approach and fine-tuning it. So let's start with the literal interpretation. Some scholars have argued that internationally recognized human rights are not placed at the top of the applicable law. So not in Article 21.1 from the very beginning, instead of the Rome Statute. There could have been human rights law. However, I think this can easily be rebutted by an argumentum a contrario if we assume that the application of a statutory norm violates human rights. Can the court apply it? And Article 21.3 plainly says that the application must be consistent, and I quote, must be consistent. The phrase denotes an obligation, and there are no exceptions there too. So from the perspective of Robert Alexis' theory, it is a rule. There are no exceptions to this rule when we tried to determine the ambit of its application. So literal understanding of Article 21.3 actually supports the superlegality approach. When it comes to the second argument about the structure and wording, it is argued in academic literature that the drafters did not include the concept of internationally recognized human rights in paragraph 1, placed it at the very end of Article 21, and could have in principle formulated Article 21.3 in much stronger terms. For instance, I quote, subject to its consistency with human rights, the court shall apply. However, the drafters did not do that. My counter argument to this would be that the allocation of a provision is simply irrelevant. And I can refer to EU law. I'm not sure whether there are EU lawyers in the conference, but we can recall the Charter of Fundamental Rights of the European Union, and one of its most important provisions, Article 52, which is the cornerstone of the whole system of EU human rights protection, and it's in the very end of the whole treaty, let alone at the end of the provision. And it's still of fundamental importance. I agree that the formulation of Article 21.3 of the Rome Statute could have been better, but the fact alone does not suffice to reject the superlegality approach. The third argument concerns contextual interpretation. And here it's a bit more tricky. A reference is usually made by the critics of the superlegality approach to Article 69, paragraph 7 of the Rome Statute, and you can see it on the screen now. Evidence obtained by means of a violation of this statute or internationally recognized human rights shall not be admissible if, and then there are two safeguard human rights clauses. So the argument goes that the disjunctive or this statute or internationally recognized human rights means that they are placed on the same footing. However, the word word or, in my opinion, can mean and or, the caveat being that or negates any mandatory cumulative effect of the options. So if or meant exclusive disjunction, it would lead to manifestly absurd results. For instance, one cannot gainsay that the right to liberty exists both under Article 55 of the Rome Statute and as an internationally recognized human right. So it is inclusive, and it may point to either the statute or internationally recognized human rights, or both. This does not, however, relieve us from the fact that Article 69.7 permits the admission of illegally obtained evidence. So how can the ICC apply the law inconsistently with internationally recognized human rights as required by Article 21.3? And I would argue that the norm on admissibility under Article 69.7 must be read within the delineated scope of its application. Let's recall the Alexis theory again. So it constitutes an exception to the norm on consistency under Article 21.3 in all cases involving the admission of evidence. In any event, the ICC is not totally anti-human rightist as far as the fruit of the poisonous tree dilemma is concerned. Not every human rights violation will be tolerated, even when it comes to the admission of evidence, and the prohibition of torture would be a notable example. However, judicial discretion will be exercised here on the basis of the two safeguards, A and B, under Article 69.7, which you can see on the screen. And they would concern the non-reliability of evidence and the detriment of evidence to the integrity of proceedings. The ICC has used this provision, which you can see on the screen, in its case law. Thomas Lubanga, in the proceedings in the confirmation of charges, claimed that the evidence obtained in the Democratic Republic of the Congo by means of the search and seizure of the witness house breached the right to privacy, and the ICC agreed. The right to privacy was breached. However, these two safeguards under Article 69(7) led the court to conclude that there was no breach of the Rome Statute, and the evidence was eventually declared admissible. Still, how can the ICC measure the seriousness of a human rights violation? Does the end justify the means? And this leads me to the fourth element of the critique against the superlegality approach, the one based on teleological interpretation. So it is argued that the vague concept of internationally recognized human rights cannot impede the realization of the object and purpose of the ICC. International crimes, the argument goes, must not go unpunished, and their effective prosecution must be ensured. A reference is made to the preamble of the Rome Statute. So justice appears to be measured by the outcome that is favorable to victims. However, one of the foundations on the aims of the present-day international criminal law is to foster abidance by human rights. And the inclusion of Article 21.3 is a verbalized proof of this tectonic shift in international law, starting from the Nuremberg and Tokyo tribunals and up to today. And even if this quotation from the preamble of the Rome Statute sets out the only raison d'etre of the ICC, which is debatable, the only, perhaps not, it still cannot reduce the requirements of Article 21.3 to zero. So nowadays, respect for human rights is regarded as a precondition for or a means to mete out justice, international and domestic criminal law. So it underlines the legitimacy of international criminal tribunals as well. In this connection, the Lubanga Appeals Chamber emphasized, and I quote, "A fair trial is the only means to do justice. If no fair trial can be held, the object of the judicial process is frustrated and the process must be stopped." End of quote. So it appears that this reasoning does not tally with the Lubanga pretrial chamber in the decision on the confirmation of charges about the right to privacy. So one of the ways of dealing with the juxtaposition of a fair trial and justice is to delimit their scope of application. That is, to consider that the right to a fair trial exists independently from the duty to prosecute international crimes. This approach seems to have been adopted by the Lubanga Appeals Chamber. Another way of thinking is that the right to a fair trial constitutes a principle that can be balanced. This approach seems to have been adopted by the Lubanga pretrial chamber. However, recalling the Robert Alexis theory, again, the question is that the same norm cannot be a rule and a principle at the same time. How shall we deal with this seeming logjam? And the way out is with the aid of the so-called core and mantle model of human rights norms. I would refer here to my supervisor, Martin Schein, who based his argumentation on Robert Alexis again. And Martin Schein argued that most, if not all, human rights include an inviolable core within the with the character of a rule. It is surrounded by a much broader principle that is valid at the level of the legal order as a whole. So therefore, there is a core, or to be precise, a number of cores of the right to a fair trial and a broader principle surrounding it, or them. Balancing in the non-core dimension occurred in the decision on the confirmation of charges in Lubanga, but the cores of the right to a fair trial were not violated on any of the occasions. And the final argument which I want to rebut concerns the preparatory work. The argument based on travaux préparatoires, in my opinion, is not compelling. And it does not benefit from the result of the preparatory work because the fact that the drafters initially perhaps wanted to constrain the ICC finds no support in what they eventually agreed on and signed in Rome in 1998. Indeed, the travaux préparatoires can support virtually any construction, which is one of the reasons, by the way, why the Vienna Convention on the Law of Treaties vests them with merely an auxiliary role in treaty interpretation. most negotiations at the Rome conference were informal, and there are no complete written records, which again adds less weight, which makes me add less weight to any argument based on the travaux préparatoires. And finally, I will address a question of the applicability of the superlegality approach to procedural legal norms and substantive legal norms. The former perhaps is not questionable by most of the participants of this conference. If there's a right to a fair trial in a human rights instrument, the ICC can use that, and perhaps even it can trump the provisions related to the right to a fair trial within the Rome Statute. The problem is with the substantive legal norms. Let's say the war crimes against child soldiers, which have been debated today at the conference. My argument is that superlegality approach is equally applicable to both procedural and substantive norms. And the principle of nullum crimen sine lege, nullum pene sine lege, the whole principle, or two principles, is not breached due to the fact that this principle itself is an internationally recognized human right. We can refer to plenty of instruments, starting from universal human rights instruments, going to the regional human rights instruments, and domestic and general principles of law based on a thorough comparative analysis of various domestic legal systems. This has been done in academic literature, and thank you, Dr. Bradley. I see that. I'm going to finish now. Give me please one minute or so. Based on that, the nullum crimen sine lege principle is an internationally recognized human right itself. When we refer to internationally recognized human rights under Article 21.3, we, amongst others, refer to the principle of nullum crimen sine lege as well. And then in this interrelationship, dynamic interrelationship between various human rights, among which we can find nullum crimen sine lege, we can rely on the lex specialis approach in certain occasions, and then determine the scope, the ambit of application of nullum crimen sine lege in a specific circumstances of a case. To conclude, the superlegality approach is largely speaking correct, but in light of the Robert Alexis theory, and more specifically distinction between rules and principles, I would sum up and claim that serving as a conflict avoidance technique, Article 21.3 places internationally recognized human rights rules above any other rules, including those in the Rome Statute itself, but except for those which are jus cogens, and the rule on the admission of evidence under Article 69.7, which, however, has its own human rights safeguards. At the same time, Article 21.3 of the Rome Statute is less helpful to the exercise of balancing internationally recognized human rights principles can yield to other principles so long as the inviolable core of the former is not infringed. Thank you very much for your attention. I hope you are still full of beans at the end of such a productive conference, and I look forward to a fruitful discussion. Thank you.
Thank you so much, Dr. Massol. We also look forward to your forthcoming article, especially after this very interesting presentation. Now there will be about 10 minutes, but we'll see how lively the discussion is. We can perhaps continue if the audience isn't too tired after all of this discussion for questions. So you are welcome to raise your hands, or if you cannot raise your hand, there was an issue in the previous panel, then you can also just type that you have a question in the comments box, and I will give you the opportunity to ask your questions. Wonderful. Alejandro Sanchez, please, you have the floor. Oh, I cannot hear you, Alejandro. Maybe you are... Yeah, we can't hear you. You're also welcome to type your question and I can ask it for you if you struggle.
Maybe not. No.
Wonderful, we can hear you, yes.
Yes, you can hear me now? Okay, thank you. I don't know, but I have to change like somehow here. Well, I have a question for Professor Hoffman, a reflection and a question, if I may. Well, thank you very much for your presentation. I always enjoy any topic related to custom international law. It's a very complicated topic. I really like it very much. I think it may be useful to include also in your reasoning the works of the Special Rapporteur Kaliki on the judicial principle of delegation to extradite or prosecute, because he proposes, for example, the use of custom and international law for this principle, following also Judge Suer in the Belgium versus Senegal case before the International Court of Justice. So this is maybe one more example of how custom and international law can play a role in international criminal law. And just briefly, my question, I was also very happy when I heard at the end of your presentation the role of Professor Cassese in the ICTY. I didn't know about that case. I knew about a very similar one in the Special Tribunal for Lebanon, where he was president. Also, in this case, I wanted to ask you, because he was very criticized by many criminal lawyers, such as Professor Kayan Boss, because he offered in a judgment a definition of the crime of terrorism based on custom and international law, a crime that didn't exist in Lebanon when the crimes were committed. So it was said that it was some kind of counterproductive, because it was very criticized, the role of custom and international law here. So as far as everything I read about it was negative regarding this opinion of the use of custom and international law in the Lebanon case, I would like to know your personal opinion about that case. Thank you very much.
Okay, thank you very much for your question. I have to admit that I had sometimes difficulties hearing you. So if I'm correct, you want to hear my opinion about Professor Antonio Cassese's role at the Lebanon Tribunal and his proposed definition of terrorism as a customary international law definition. Okay, so first of all, I mean, please forgive me for the shameless self-promotion, but I have an old article about the role of Antonio Cassese. It doesn't address actually the Lebanon court, because it was written before that. Before that judgment. So if anybody's interested in my work of Just Cassese, I have an article, has a very long title. It's entitled The Gentle Humanizer of Humanitarian Law, Antonio Cassese and the Creation of the Customary Law of Non-International Armed Conflicts. So it's extremely long, but hopefully the paper is better than the title. But anyway, so when it comes to his role at the Lebanon court, I think he tried to pull a Tadic there. It's that simple. I mean, nothing in that case made it important or necessary to address the customary law definition of terrorism. It was completely unnecessary, but Professor Cassese wanted to do it because that basically underlined or his own professional interests. And I mean, if you have read his international criminal law textbook, you know that that was exactly his own opinion about the customary status of the crime of terrorism. And surprise, surprise, he managed to put that into the judgment. Now, of course, and this is what I highlighted in my presentation, you need very, very specific conditions to be able to pull all that off. So it didn't work out there. It's that simple. And one of the most important reasons why it doesn't work is that it has been rejected by the scholarly community. Unlike the Tadic case, because in the Tadic case, and this is something I also analyze in my article, scholars who just 1 or 2 years prior to the Tadic decision basically said that there is no such thing as customary war crimes in non-international armed conflicts, suddenly changed their minds right after that and wholeheartedly supported this conclusion. So this is something that didn't happen there. So I think we can say with quite a bit of certainty that his attempt at lawmaking didn't succeed at the Lebanon Tribunal.
Thank you. Do we have any further questions? There's one hand raised. Oh, Gus, wonderful. Dr. Wasserford.
Hi, thanks, Marty, and thanks to all the speakers. I think I'm unmuted. I hope you can all hear me. We don't have that much time, so I can't ask questions to everybody, which I would have liked to do. The first is just a bit of an observation in regards to Tamash's one point regarding the approach that Tadic took to recognizing customary international law. And this links back to one of the points Peter made in the previous session, where he mentioned that in the Special Court for Sierra Leone, reliance was placed on a Tadic formulation to determine whether the child soldier offense in that context had crystallized into a customary international law crime. Now, as Tamash mentioned, you know, the grounds for recognizing customary norms, both on the basis of state practice and the underlying opinio juris in Tadic, was perhaps spurious at times. And I think this is my observation, that this is where the problem lies, because it allows for the kind of creep we see that happened in the Special Court for Sierra Leone then, because what happens is they try to adopt the same approach, but they rely on even more spurious grounds to determine the existence of both state practice and opinio juris. And then I should add, this is more technical, but they actually misapplied big parts of Tadic in that judgment also, which obviously made more complicated the matter as a whole. But I mean, I would suggest that this is one of the problems with this kind of lawmaking that we spoke of. And then my second point is more of a question, and that's to Sergey, and that is regarding this approach, sort of conflict avoidance approach that you spoke and you referred to Martin Scheinen's work on the core and the principles surrounding the core. Is there anything to be done with this approach to be applied in avoiding conflict of norms between different regimes of law? So IHL and human rights law and these sort of more popular topics also. Thank you.
Thank you very much. Sergey, you're welcome to respond and afterwards also raise your question.
Okay. Thank you very much for the question. I think that the core and the mantle approach of Martin Scheinin, which essentially is based on Robert Alexie's theory, helps to better understand that where we see the rules and where we see principles, in particular human rights rules and human rights principles, or international criminal law, law rules and international criminal law principles. But then at the end of the day, it boils down to that tripartite framework of principles versus principles, balancing principles versus rules, not existent, and rules versus rules. And here we can use either the exception doctrine, so this rule is an exception to another rule, or a number of legal maxims. And one of them is that lex specialis derogat lege generali, or any other conflict avoidance techniques of this kind. Lex posteriori derogat lege priori, and so on and so forth. So in this respect, the core and the mantle model helps to get this whole picture of rules and principles, and then other legal maxims can be used effectively to aid the interpretive process. So I hope I responded to your question. And if I may, I would like to ask a question to another panelist. Or should I do it later?
Please do. You're welcome to ask your question.
Thank you. So I would like to ask a question to Ms. Ragavi Viswana. Sorry if I mispronounce the name. I'm very glad to see a person from the EUI in my panel and also in other panels. The EUI is great, as we know. The question concerns the principle of legality in the jurisprudence of the ad hoc tribunals, the Yugoslavia, former Yugoslavia, and Rwanda. As far as I remember your PowerPoint presentation, you did not discuss it at all. Of course, it is not explicitly mentioned in the statutes of the ad hoc tribunals, in contrast to the Rome Statute of the ICC. but don't you think that that is also part of this grand interpretative edifice that you outlined at the very beginning of your presentation? Later on, you emphasized that the principle of legality under Article 22 of the Rome Statute is one of the main advancements of international criminal law, and here I agree with you, but then you kind of forgot to mention it as regards to ad hoc tribunals, although I would say it's still applicable, and it has been used in the case law of the former Yugoslavia Tribunal quite a lot. And then another part of the same question concerns the principle of legality within the framework of the Rome Statute. You mentioned on the very same slide, so that Article 22 was one of the main advancements, and then at the same time that there is a continuing trend of humanization of international criminal law. And I think you referred to the Ntaganda case. And the question is basically, is there any inconsistency with that? So don't you think that the principle of legality under the Rome Statute has a stricter formulation than that under customary international law, which was used by the ad hoc tribunals? And thus, the continuing trend of humanization is actually impeded, or should be impeded as a normative argument, because of the inclusion of Article 22 under the Rome Statute. Thank you.
Thank you for both of your questions. In response to the first, the reason I didn't identify the principle of legality as a separate approach is because I think when you look at the wide array of interpretive approaches, legality is subsumed between many of them. For instance, when you speak of the literal rule, or when you speak of the logical construction, legality is often a justification offered for the invocation of one of these approaches. And that's why I did not treat legality as a separate approach per se, both in the practice of the ad hoc tribunal and the ICC. I think it is an interpretive aid to corroborate the invocation of one of those approaches. And in continuation, to answer your second question, I agree that the Rome Statute's formulation of legality is much stricter than customary law. But and I think that humanization is therefore impeded. But we do see that the ICC is not fully loyal or faithful to the strict understanding of legality, and continues to find room for exceptions, like it did in the Ntaganda case. And that's what I meant by this still a continuing trend of humanization, while not so pronounced as the ad hoc tribunals, but it still does exist.
I have a related comment to Sergei's question and to your own answer, Nagbani. My apologies for my pronunciation. I mean, there is an obvious tension between the principle of legality and any interpretative approaches pursued by the court, and the court has been aware of this. I mean, the court in the Ntaganda case said, I mean, it responded to the defense argument saying that yes, it does appear as an interpretation pursuant to judicial activists, but then it continued on and said that no, it's founded on the Rome Statute, on international law in general, and IHL in particular. But we can see this tension in other areas as well. I think the most illustrative example will be the use of Regulation 55 by the court. And it's very controversial use actually to change the mode of and to change individuals' mode of participation very late in the proceedings. So this tension is obvious not only with respect to the crimes interpretation, but other aspects of the court's work, which may appear more peripheral to our discussion right now.
I think Roger might want to add in on this point. You're welcome to do so.
Yeah, hi, thanks. I can actually, yeah, I had one comment as well to that issue of the principle of legality as it's incorporated in the Rome Statute, which is, in my view, actually a lot more restrictive than the customary principle would be, or the general criminal law principle would be, because of the specific language that gives such an easy way out for the court, because it says that a person shall not be criminally responsible under the statute unless the conduct in question constitute at the time it takes place a crime within the jurisdiction of the court. And that is obviously then you just have to put something in the statute as a war crime, even though it may not at all be a violation of international humanitarian law. And the statute itself is adopted in 1998, entered into force in July 2002. But so a state can can accede to the Rome Statute many years later. And the actual conduct, if it wasn't a violation of IHL at the relevant time, then the only way for the principle of legality to not be breached is if, well, it is breached, of course, then if the statute is then retrospectively applied to that conduct just by virtue of it being included in the Rome Statute. And the most clear example would perhaps be the crime of attacking peacekeepers or members of peacekeeping operations, which is Article 82B4, I think, and Article 82E3. Where, of course, this is related, for example, to in the Banda and Jirbo case, or first in the Abu Ghraib case, to conduct in Sudan, whilst Sudan has never been a member of the 1994 Convention on the Protection of Peacekeepers, and Sudan is not even a state party to the Rome Statute. So where do you then find the violation that this crime is based on? Yet the court would never have to deal with it because it was a crime under the Rome Statute. So Article 22 is completely fulfilled. And that's obviously not what really the principle of legality was about. I've proposed in a chapter somewhere that then the court should be applying the Tadic conditions, as, for example, this morning we were discussing, or Renata was referring to the Tadic principles being applied by the Special Court for Sierra Leone. But I'm sure the court will never do that if it's dealing with a case that concerns something that is a crime in the Rome Statute. The way out, of course, is to see the Rome Statute as a criminal code. In the Nataganda, the 4 January 2017 decision on the members of your own forces, there is a paragraph which specifically says, like, well, it's a crime under the Rome Statute, and the Rome Statute is applicable in this specific situation by virtue of the Congo having signed up to the Rome Statute. So the issue is sort of moot. So that's one comment. Then I wanted to just add something to Tamas's presentation, where I think you referred to Ongwen being the latest, which referred not much to customary law, but I've only gone through it very quickly now, but I've seen a number of references to IAC rules, even though this, of course, was also found to be a NIAC. So it's implied then, of course, by the chamber that this is a rule of customary international humanitarian law, otherwise they couldn't be applying it to a situation of non-international armed conflict. And even though they very often, chambers won't explicitly say so, in Nataganda the decision will always have explicitly said so, but that's another way to kind of find implied references. And there are a lot that way, where they basically fail to acknowledge that obviously this IAC rule can only through customary law apply to an IAC. All right, thanks.
Rocky, if you want to interject at this point, since you've had so many comments, and then perhaps Alexander could pop in afterwards.
Sure. I think what Roger has said now about how legality, the way it's constructed, already gives the court an easy way out that possibly offers an explanation for why you see that this conflict still makes the court lean towards a more teleological reading, a humanized reading whenever it finds the opportunity to do that. And yeah, that's all I had to say about the comment. I think it is completely valid.
Alexander?
Yes, you can hear me. Yes, well, thank you very much. I'd like to follow up on Roger's suggestion of the case study in Banda, as I also worked on a related issue, and I read with great pleasure the paper of Roger. But now I'd like to focus on the panelists. And now I just want to add an element on this. I mean, of course, nullum crimen sine lege is part of the internationally recognized human rights, even if the definition of nullum crimen sine lege as contained in Article 22 does not allow for questioning whether a crime is in the statute or not, or whether it applies at the time where it was committed, given that the statute entered into force and as such. Now, I'm just adding one word to trigger Sergei's response. And so nullum crimen sine lege, and now in the infamous terrorist case at the STL, was qualified as jus cogens. And now I'd like to hear Sergei with his principles, rules, and the impact of jus cogens and so on how the statute works. I'd like to hear his answer. When we qualify nullum crimen sine lege as jus cogens, does it changes its effect on how the court has to interpret whether or not a crime was applicable at the time of the offense? Thank you.
Sergei, you're welcome.
It was not too complicated.
Thank you, Skander, Dr. Galan, sorry. I think that the principle, to begin with, I doubt the principle of legality is a jus cogens norm. The STL jurisprudence, the decision which you referred to, is not one of the most persuasive, does not have one of the most persuasive legal argumentation, in my humble opinion. I don't think this argument would find much support from the jurisprudence of other international hybrid criminal tribunals. You can argue that it is leading to becoming or getting that status. And I think one of their arguments why I think so would be perhaps a historical argument. So when we look at the tribunals in the aftermath of the Second World War and Hans Kelsen's understanding of principle of legality as a principle of justice, which does not necessarily have to be followed, and then the gradual development of international human rights law in the Cold War times, and finally the renaissance of international criminal law in the 1990s. So we can see that the position or the weight of the principle of legality has been increasing throughout history. So I would claim that it's not the STL that could make such a bold argument about the jus cogens status of the principle of legality under customary international criminal law. It would perhaps be the ICC that can claim that in the future on the basis of the strong wording of Article 22 of the Rome Statute. And then within the context of this specific treaty, the Rome Statute. Let's assume it is a jus cogens norm. If that is the case, then it would be easier to use the principle of legality. Then it would probably be regarded as a rule in all respects that would trump other rules, which could be in a seeming or potential conflict with it. So it would indeed, to repeat the same, it would indeed bolster the weight of this principle.
Thank you for that answer. Do we have some further final, I will take one final question, since we're having such riveting discussion, but we're also over time. A final question, or perhaps some final remarks from any of the panelists? Everyone happy? or exhausted after such a lively debate. Thank you so much, everyone, for bringing your A game in the graveyard shift after lunch. I would like to thank you, all the panelists, for reigniting my personal interest in Article 21 of the Rome Statute and also looking beyond Article 38 ICJ. This was really a wonderful discussion. I thoroughly enjoyed all the papers. I'm sure everybody did, especially Professor Hoffman. I will be re-looking the relationship between customary international law and Article 21. That is not something as an IHL lawyer primarily that I have created. I just want to also thank the organizers and compliment them on such a gender inclusive panel and also a geographically diverse panel. I think that is really something we don't always see, such a balanced panel also in terms of excellent quality. So I must applaud the organizers for that. Do we have a final word from Andre or from Martin? I have a raised hand. Prof. Hoffman, did you want to say something? Oh, it was an applause. Sorry, I'm still getting used to Zoom. Okay, that was a clap for gender equality. Thank you so much. Andre, Martin, final words for tomorrow?
Well, thank you so much to all of you. We are used that when Tamás is on board, that we always have good discussions because his contributions are usually very thought-provoking. But I can say that this panel was that all the contributions were very thought-provoking. So I'm very glad about this, and thank you, Marty, for chairing the panel in such an excellent way. Thank you to all of you for staying with us in the afternoon session until now. I think we are still fine in terms of time, even though we made it a bit like 20 minutes longer, but it's still academically acceptable, I would guess. So we will meet if you want to, and we will continue tomorrow. We will start with the morning session chaired by Professor Strydom. And I'm looking forward to that. Thank you for being with us. Maybe Andre wants also to add something. We can hear you. You are not muted, but the microphone apparently does not work for some reason. Well, I guess, and I hope that since everybody will, we do very much hope that everybody will join us also tomorrow. So we will try to fix Andre's microphone for tomorrow, so he will be able to give his compliments to all of you tomorrow in the morning, because I'm sure that it was about the compliments to all of you. So thank you. Thank you and bye-bye.